It's been 8 months since the country was captivated by this image.
I am very eager to get on with the evidence.
Finally, the most anticipated trial in history has begun.
All the defense is trying to do is get justice for our client.
Did O.J. Simpson commit murder?
The evidence is consistent and very powerful.
The time for speculation is over.
It's time to stop talking and postulating. Let's go to trial.
From Los Angeles, the O.J. Simpson trial, the opening statements.
Hello, I'm Greg Jarrett. The eyes of the world are focused here in Los Angeles. In fact, on this very building behind me, the Los Angeles Criminal Courthouse, where the much-anticipated murder trial of O.J. Simpson is about to begin.
I think we're going to see one of the hardest-fought legal battles in my recollection, certainly. I anticipate that both sides will spend a lot of time walking on the edge of the legal envelope here. And believe me, I will do everything I can to keep you from going over that edge. I expect to see a demonstration of absolutely fabulous lawyering skills, but I also expect to see absolute professionalism in this endeavor. I want you all to remember before we start this case that your conduct here will have an impact not only upon the welfare of your respective clients, but upon the image of our profession for many years to come. Those who say the criminal justice system itself is on trial may be correct in that observation.
Since June 12, 1994, when Nicole Brown and Ronald Goldman were brutally murdered, speculation and innuendo has run rampant. Did O.J. Simpson murder his ex-wife and her friend, or did police botch the investigation and let the real killers get away? And now, inside the courtroom of Judge Lancito, prosecutors and defense attorneys will try to answer these questions once and for all, in front of the only audience that matters, the jury.
Good morning, ladies and gentlemen.
Convincing the jury of O.J. Simpson's guilt or innocence will be up to these two teams of legal heavyweights. Leading the prosecution is Marcia Clark, a steely prosecutor who has tried over 20 murder cases. Clark shares responsibility with William Hodgman and Christopher Darden. Hodgman is best known for winning the conviction of savings and loan financier Charles Keating. Christopher Darden, a 14-year veteran of the district attorney's office, will lead off the state's case.
All right, are both sides prepared to go forward?
In his opening statement, Darden will draw a roadmap of the case he intends to present.
I think it's fair to say that I have the toughest job in town today.
Darden begins by posing to jurors the most asked question of the year.
Did O.J. Simpson really kill Nicole Brown and Ronald Goldman? Well, finally, ladies and gentlemen, I am here in front of you this morning to answer that question. And we'll answer that question from the witness stand and from the exhibits you'll see in this case and from the evidence. And when you see the evidence and when you hear the witnesses and when you put it all together and consider the totality of circumstances in this case, the answer will be clear to you as well. The answer to the question is yes. The evidence will show that the answer to the question is yes. O.J. Simpson murdered Nicole Brown and Ronald Goldman.
Darden portrays O.J. Simpson as a man with two sides. In public, the likable football hero and movie star. In private, a vicious abuser, and finally, a killer.
He may be the best running back in the history of the NFL. We watched him leap turnstiles and chairs and run the airplanes in the Hertz commercials. And we watched him with a 50-inch afro and Naked Gun 33 and a half. And we've seen him time and time again. And we came to think that we know him. What we've been seeing, ladies and gentlemen, is the public face, the public persona, the face of the athlete, the face of the actor. It is not the actor who is on trial here today, ladies and gentlemen. It is not that public face. It is his other face. Like many men in public, like many public men, they have a public image, a public persona, a public side, a public life, and they also have a private side, a private life, a private face. And that is the face we will expose to you in this trial. the other side of O.J. Simpson, the side you've never met before. We will expose in this trial and show to you in this trial that other face, the face he wore behind the locks and the gates and the walls at Rockingham, that other face, the one that Nicole Brown encountered almost every day of her adult life, the one she encountered during the last moments of her adult life, the same face Ronald Goldman encountered during the last moments of his life. When we look upon and look behind that public face, the public face of the man who sits here in court today, you'll see a different face. And the evidence will show that the face you'll see and the man that you will see will be the face of a batterer, a wife beater, an abuser, a controller. You'll see the face of Ron's and Nicole's murderer.
Darden offers a motive why he contends O.J. Simpson murdered his ex-wife.
He killed her out of jealousy. He killed her because he couldn't have her. And if he couldn't have her, he didn't want anybody else to have her. He killed her to control her. Control is a continuing theme. It was a continuing theme. The central focus of their entire relationship. He killed Ron Goldman because he got in the way.
With both O.J. Simpson's relatives and the victims' families looking on, Darden details a pattern of abuse and control that continued throughout O.J. Simpson and Nicole Brown's 17-year relationship.
The more control he gained, the more abusive he became. As you listen to the evidence in this case, you're going to be hearing evidence regarding domestic abuse, domestic violence, stalking, intimidation, physical abuse, wife beating, public humiliation. As you listen to the trial and as you hear this evidence and see this evidence, please keep in mind that all of these different kinds of abuse were all different methods to control her when she was pregnant and put on weight. The evidence would show that this defendant was so abusive that he called her names. He called her fat. He called her a pig. And he did this in the presence of her family and in the presence of her friends.
Darden tells jurors that O.J. Simpson physically abused his wife, too.
You'll be hearing evidence. You'll be hearing testimony. You'll be seeing witnesses in this case regarding an incident that happened on January 1, 1989. It was almost 4 o'clock in the morning on January 1st when the 911 operator received a telephone call from Rockingham. And that operator will be here to testify in court. And that operator will be here to authenticate the tape of that 911 call from Rockingham. And when the operator appears and when the tape is played, listen very carefully. Because if you listen carefully, in the background you will hear a woman screaming. And you will hear something else. You will hear the sound of this defendant, this man, beating this woman. You will hear the sound of his hand smacking across her face. You will hear the sound of this defendant beating his wife. She comes running out of the darkness and out of the mud and out of the bushes. And she pushes a button to the security gate and she runs through the gate and she collapses in the arms of the officer. The entire time she's yelling, he's going to kill me. He's going to kill me. And the officer said, who's going to kill you? And she said, O.J. is going to kill me. And the officers looked. They looked at Nicole. Her eye was swollen, bruised. Her lip was cut. One of the officers, the senior officer there, he looked at her neck. And what he saw startled him. On her neck, he could see the imprint of a hand. The imprint of a hand around her neck.
Even after Nicole and O.J. Simpson separated, Darden claims the former football hero just couldn't let go. When Nicole dated other men, Simpson was there too, waiting and watching.
It was about 3 in the morning. And they were seated on the sofa in her living room. The kids were upstairs asleep. It's 3 o'clock in the morning. And Keith and Nicole made love on the couch. But they weren't alone. There was somebody watching. There was someone watching through the window. It was the defendant. At 3 o'clock in the morning, he was looking through Nicole's window, watching her make love to another man. And the next day, when Keith and Nicole were together, he walked right into her house. And he was beside himself, and he was angry. And he said some very naughty things. But one of the things that he said to Keith and Nicole was that he said, I watched you last night. I watched you and I saw everything.
Incident by incident, Christopher Darden has tried to create a strong impression that it is not O.J. Simpson, the celebrated athlete and actor on trial, but a wife abuser whose final act of control was murder. But convincing Judge Lance Ito to allow the state to introduce evidence of an abusive relationship was a battle the prosecution waged even before the trial began. The defense argued the evidence would prejudice O.J. Simpson's right to a fair trial because it had nothing to do with the events of June 12th. But the judge agreed with the prosecutors that such evidence was important and relevant and could be admitted to try to prove that Simpson had a motive and the intent to murder his ex-wife.
We will show you the other side of the smiling face you saw in the Hertz commercial, the one you never saw on camera, the one none of us ever wanted to see.
Now, lead prosecutor Marcia Clark, continuing the prosecution's opening statement, presents the most graphic and compelling evidence, the blood. First, Clark tells how neighbors of Nicole Brown Simpson discovered the bodies.
So at 10:15, Pablo Fenbez heard a dog bark. He remembered it clearly because the bark was like a plaintive, insistent wail. It was like nothing he'd ever heard before. Although he'd heard dogs barking in the neighborhood often, other dogs lived in that neighborhood. This was different. This bark sounded to him like a dog in trouble. At 11 p.m., when Pablo Fenbez went to bed, the dog was still barking. He went over to his bedroom shutters and opened them to look out in the direction that the barking seemed to be coming from. And he looked in the direction of Nicole's condominium, which is the direction it seemed to be coming from. And he noticed that there were lights on in the upper floor of her condo. When he fell asleep, shortly after 11 o'clock, the dog was still barking. The evidence will show that this dog, wailing and barking so insistently, was Nicole's white Akita, Kato. Another neighbor, Steve Schwab, left to take his dog for a walk at approximately 10:30. At about 10:55, when he got to the corner of Dorothy and Bundy, which is right on the corner of Nicole's, where Nicole lived, maybe one house down, he saw Kato the dog walking alone. The dog was acting very agitated, seemed to be barking at the house on the corner of Dorothy and Bundy. He couldn't tell which one. And he noticed that the dog had an expensive collar. When he checked it further, looking for tags, he noticed that there was blood on the paws and on the legs of the dog. Although at that time he saw no injury, he assumed there must have been a cut on the paw to cause all that blood. As he continued to walk, the dog began to follow him, but it behaved in a very strange manner, because at the walkway to every house that they passed, the dog would stop and bark insistently. When Steve got home at approximately 11:05, he and his wife discussed what to do with this dog. They sat outside, gave it some water because it seemed very dehydrated, and decided to try and get it to lead them to its owner's home. So they took it out, and they started to walk back, but as they neared Bundy, the dog resisted. The dog pulled back, and they couldn't get it to go any farther. So they took the dog back to the courtyard of their apartment building. Now, in that courtyard, there was more light, and they were able to see more clearly that there was no injury on the dog, but that its paws and its legs were clearly bloody. Now, Steve Schwab later gave that dog to another neighbor in his apartment building, Sukru Bostepi. You'll see them testify in this courtroom. And Sukru Bostepi agreed to take care of the dog for the night. But again, the dog was acting very agitated with Sukru Bostepi. He tried to take him inside the apartment, and he was sniffing and scratching and trying to get out. So he tried to do the same thing that Steve did. And he took the dog out for a walk, hoping it would lead him back to the owner's home. As they went south on Bundy, the dog started pulling harder and harder until they got to the location of 875 South Bundy. And there at the pathway leading up to that home, the dog stopped. And the dog looked up the pathway, and that made Sukru look up the pathway. And there he saw a sight that he'll never forget. He saw the body of Nicole Brown lying at the foot of the steps in a pool of blood.
That blood, Clark said, leads straight to O.J. Simpson. It was found on his Ford Bronco.
The detectives noticed that there was a small spot of blood near the driver's handle of that door. And there's the glove where it was found, in the very same location in which it was found that night, right next to the air conditioner on that narrow path. When they saw that glove, they realized that it looked like the mate to the glove that you also already saw at the Bundy scene underneath the plant at the foot of the body of Ron Goldman. They then realized that perhaps they needed to secure the residence, and Detective Van Adder then walked out of this pathway and out onto the driveway. When he walked out onto the driveway, what Detective Van Adder saw, now that it was becoming light, it was at least 6 o'clock in the morning at that point, were blood drops on the driveway that led from the Bronco and all the way into the house.
P41,
And close up,
P42,
and there's the blood drop, one of the blood drops that was seen. On the-
P43,
This was inside the house. This is right inside the front door in the foyer area. There were a series of 3 blood drops here, close up.
P44,
You can see them here. I'm circling them. Having seen all of this, the detectives then realized that this was not just an occasion to make notification, that in fact they had uncovered evidence that indicated that the defendant had committed these murders.
The blood evidence then underwent extensive DNA testing. Marcia Clark explains.
And the tests are really tests of exclusion. What does that mean? That means that when you conduct these tests, the effort is to exclude. You analyze the DNA and you see, can I exclude the suspect? Can I rule him out? Is there anything here inconsistent with the suspect or the victims, depending on what you're looking at? And that's exactly what was done in this case. With every piece of evidence collected, the effort was to exclude the defendant and to exclude the victims. That was the focus, and that is the aim of DNA testing. In this case, we asked this question over and over and over again. Can the defendant be excluded? No matter how hard we tried, over and over, the samples were tested and retested and tested again. Over and over again, we asked ourselves, can the defendant be excluded? And over and over and over again, the answer was no. The defendant cannot be excluded.
Clark meticulously presents the test results of the blood and fiber evidence.
The ski cap that was found at the feet of Ron Goldman was examined for hair and trace analysis, and it was found on that knit hat that there was fiber like those from the carpet of the defendant's Ford Bronco. Now stop and think. Why would there be carpet fibers like those from the defendant's Ford Bronco?
That's true.
Okay.
Just state what the evidence is. Thank you.
Also on that knit hat, we find hairs like those of the defendant. Which is what you would expect to find on a hat worn by the defendant. Your Honor, the next one.
Because of their graphic nature, Judge Lancito and attorneys for both sides agreed not to broadcast certain crime scene photographs.
On the shirt of Ron Goldman, we find a head hair like that of the defendant. On the glove found at the defendant's home at Rockingham, we find hair like those of Nicole Brown, hair like those of Ron Goldman, fibers like those from the shirt of Ron Goldman, and fiber like those found in the carpet of the defendant's Ford Bronco. This shows you the defendant's Ford Bronco. You see the tags? Those all indicate blood spots that were recovered on June the 14th. The blood stain on the panel, and that's, I'm going to try and indicate it with the red light because it's at the edge of the photograph where that tag is. That blood, as well as the blood on the, that blood on the panel matches the defendant.
P49.
The blood indicated here with the number 34 matches the defendant.
P50.
The blood on the panel here matches the defendant.
P51.
There's blood on the console matches the defendant. The item number 31 on the console, consistent with a mixture of the defendant and Ron Goldman.
P53.
This blood stain was on the console. This was recovered later in time, after the 14th. That is consistent with a mixture of the defendant, Ron Goldman, and Nicole Brown.
P54.
The blood stain found in this area marked with the number 33 matches Nicole. The blood spot number 6 matches the defendant.
P41.
This is the blood spot number 7 we showed you before, close up. Matches the defendant.
P42. P43.
Again, the blood drops that were found just inside the front entry of the defendant's home. This is blood drops number 12.
P44.
Matches the defendant.
P45.
The socks that we indicated earlier to you were found in this condition, thrown hastily at the foot of the defendant's bed in his bedroom. The blood on those socks was analyzed.
P46.
It was determined that the blood on one spot matched the defendant. The blood on another spot matched Nicole. The glove that was found at the south walkway of the defendant's property at Rockingham revealed blood that was consistent with a mixture of Ron Goldman, Nicole Brown, and the defendant.
P19.
These are the blood drops at the Bundy location at 875 South Bundy. This blood drop that you see here, marked with the item number 112, matches the defendant.
P21.
Matches the defendant.
P23.
Matches the defendant.
P25.
Matches the defendant.
P27.
Matches the defendant.
After months of speculation about the state's case, this is the first time prosecutors spell out exactly how they intend to prove that O.J. Simpson murdered his ex-wife and her friend. On its face, it appears to be strong scientific evidence linking Simpson to the crimes. But remember, the defense still has a chance to tell the jury O.J. Simpson's side of the story. Before that can take place, the unexpected happens. Judge Lance Edos stops the trial.
We couldn't give our opening statement today. That's really outrageous.
The judge is furious about an error made by Court TV. An alternate juror was inadvertently seen
indicated
briefly
here.
on camera during Marcia Clark's opening statement. It is not permissible to show jurors during a trial, and the judge delays proceedings while he considers whether to cut off TV coverage completely. In the end, he decides to let the camera stay, provided that it can be locked down to show only a static shot of proceedings until more safeguards can be put in place to restrict its movement.
Ladies and gentlemen, good morning to you.
After the brief delay, Johnny Cochran
indicated
begins
yesterday,
opening
I would have
statements
liked to have had this
telling the
opportunity
jury
about
how
3:30
he'll defend O.J.
address you.
Simpson against 2 charges
And it's
of
my
first-degree
opportunity,
murder.
And it's my honor and privilege, on behalf of the defense, and our defense team, as it were, to stand before you now and address you what is called opening statement.
The defense team, often called O.J. Simpson's dream team, is headed
All
by
right,
Johnny
counsel, may I
Cochran,
please be
a
seated?
powerful Los Angeles attorney known for representing high-profile clients like Michael Jackson and Reginald Denny, the truck driver beaten in the 1992 Los Angeles riots. Cochran is assisted by an all-star
All right, good
cast
morning,
of
ladies and
lawyers. Robert Shapiro, who initially headed Simpson's defense team.
Your Honor, then
Famed criminal defense attorney F. Lee Bailey.
default.
Former law school dean Gerald Ullman, and Cochran's junior partner, Carl Douglas.
The evidence in this case, we believe, will show that O.J. Simpson is an innocent man, wrongfully accused.
Johnny Cochran has a big job, disputing the mountain of evidence the state has against O.J. Simpson. Calmly and methodically, though, the 56-year-old defense attorney points out that there are 2 sides to the story.
And it seems to me that this case, the prosecution's case, based on what we heard in the evidence, will show this case is about a rush to judgment, an obsession to win at any cost and by any means necessary.
Cochran introduces 2 witnesses,
prosecution in
Rosa
this case
Lopez and Marianne
has enlisted the
Gerches, who
services-
he says will prove that O.J. Simpson could not have committed the murders. Cochran says that Lopez, a housekeeper next door to Simpson's Brentwood estate, will testify that she saw Simpson's Ford Bronco parked just outside his home at the same time prosecutors say he was committing the murders.
When she came out to walk her dog at 10:15, that same night, she looked at the Bronco, and the Bronco was parked exactly the same way, at that curb, same way. When she saw the Bronco the next morning, it was parked that same spot, the same place.
According to the defense, Marianne Gerches saw 4 men outside Nicole Brown Simpson's condominium around 10:45 p.m. on June 12th. Lopez and Gerches could be crucial witnesses for the defense. Not only could their testimony rock the prosecution's theory of what happened and when, it could play into a key theme of the defense's case, that police bungled the investigation.
The evidence will show that Marianne Gerches, after she became aware that what she had seen had some great relevance to this case, started calling the police. She kept being transferred and transferred around. Couldn't get anybody really to talk to her. Finally, when she finally reached the police officer, They told her, we've got that case all wrapped up. They didn't want to hear from anybody else. And then, lo and behold, she called the district attorney's office. Spoke to a person whose name will be revealed during the testimony. And she didn't feel she's treated quite appropriately. In fact, she will say that the person put her on hold and said, excuse me, I'm talking to a psychic right now. And I'll get back
Cochran changes gears. The defendant is a philanthropic man, he tells the jury, not the abuser and killer the prosecution described.
This man that Darden was talking about, this man gives $5,000 every year to the Angel City Links, an inner city black organization. And the condition of his gift every year is it has to be anonymous, that he doesn't want them to know he does that. The thing that he's perhaps proudest about are these next two things I'm going to tell you about. Number one is his mother, Eunice Simpson there. As soon as he was able, he bought her a house. She still lives in that house in San Francisco. This is a man, 47 years old, who grew up in the poor areas of San Francisco, in Potrero Hill, but he never forgot. Became rich and famous, but he didn't forget. So that to this day, he buys the uniforms for the kids at the Potrero Hill gymnasium where the kids go to work out. He still does that, even right now, even while in his jail cell. Bought his mother's house. You'll hear about those kinds of things. And the second thing he's most important, proud about, is that he had a child who drowned at a young age. That's always a tragedy, and you'll hear evidence about that. And the pronounced effect that it had upon him. And after that, he became involved in all of these kind of pediatric endeavors. And he has participated in raising hundreds of thousands of dollars for Camp Good Time, for kids who have cancer.
Cochran continues to chip away at the state's case, trying to raise reasonable doubt in the minds of the jurors. He says the trail of blood described by Marcia Clark does not lead to O.J. Simpson at all.
What she did not tell you was that there are trails that lead toward innocence, and they were not pursued. Let me give you some examples based upon the evidence that I expect to produce in this trial. There is, and I'll go through this list for you. Expect the evidence to show that there was blood under Miss Nicole Brown Simpson's fingernails. It came back a type B in an EAP genetic marker. And that does not fit the genetic profile of Mr. Simpson, Mr. Goldman, or Miss Brown.
DNA testing of blood evidence is often flawed, says Cochran.
So with regard to the claim that every effort was made to exclude Mr. Simpson, we think the evidence will show that that's not what happened in this case. We have to keep an open mind. We think the evidence will show that when test results pointed away from Mr. Simpson, they concluded that something must be wrong with the test. Our experts will tell you that there are huge interpretation problems with many of the tests performed in this case. This is particularly true where there are mixed samples containing blood or other biological material from more than one person. We expect to show that the results of some of the tests in this case are so ambiguous that two different scientists will come to two different conclusions with the same results.
He tells the jury that some of O.J. Simpson's blood, taken after he was in custody, is missing. The implication that this missing blood was planted on the evidence.
The fact that blood voluntarily given by a defendant mysteriously disappears when it should be there is devastating evidence that something is wrong. And finally, it seems to me that the fact that blood mysteriously appears on vital pieces of evidence and it's predicted what the results will be regarding DNA when that evidence is still in the police lab is devastating evidence of something far more sinister.
Cochran says O.J. Simpson was physically incapable of these violent murders.
We expect there will be testimony that on the date of June 12th, Mr. Simpson was involved in the acute phase of his rheumatoid arthritis. And on that date, after he had played golf, the problems with his hands were so severe he could not shuffle the cards where he played gin rummy at the country club thereafter. there'll be evidence of the limitations now imposed upon him by virtue of his career, by virtue of this disease that he suffers. And I'd like, at this point, to have Mr. Simpson come over to the jury so I can demonstrate the problem with his knees.
It is a highly unusual request, one that was hotly contested even before opening statements began.
We asked the court if, number one, Mr. Simpson could participate by giving a brief portion of the opening statement, and two, that during the course of the balance of the opening statement, there may be times, and will probably be times, when I'd like Mr. Simpson to be able to approach the jury to demonstrate certain things that I think are very relevant in the course of that opening statement.
If Mr. Simpson would like to testify, we'd be delighted to cross-examine him and to hear his testimony at the appropriate time. But counsel's motion is simply an effort to have him present testimony to the jury without being cross-examined, and there is nothing that allows him to do so under the law.
Judge Ito ruled that Simpson would not be allowed to address the jury, but he did grant a defense request that Simpson be allowed to show his football-scarred knees. Cochran says these injuries, coupled with his arthritis, made it difficult for Simpson to move around, let alone commit the murders.
There will be other
The jury also views a series of photographs of the former football star's stripped-down body. What Johnny Cochran wants them to see is what isn't there, bruises. Cochran says that if Simpson had been the one to struggle with his ex-wife and her friend, his face and body would be bruised. The message? The real killer is still out there. As the second day of opening statements draws to a close, Cochran sounds a familiar theme. Sloppy police work contaminated the evidence, making it unreliable.
All of this evidence collected, whether at Bundy or Rockingham or wherever, went through the LAPD lab. And we expect to introduce evidence that from their own records, that laboratory is a cesspool of contamination. Not up to speed, not up to standard. We think we can conclusively indicate that during the course of the testimony in this case. Thank you very much, and I would ask you to keep an open mind until tomorrow, till we have a chance to finish.
But Johnny Cochran does not get to finish the next day. The trial shuts down.
The people have been severely prejudiced today, Your Honor. Severely prejudiced. This conduct is outrageous and unbelievable.
After repeated objections, Prosecutor William Hodgman erupts. He says the state has been deceived by the defense, claiming they kept key defense witnesses, including Marianne Gerchis, a secret until trial.
Your Honor, there is a myriad of issues that have been raised by the acts of the defense today, an absolute myriad of issues. The people need some time to digest this. I realize this comes at a difficult time in the proceedings, but I don't think in the history of jurisprudence have we ever had anything occur like what happened today in this courtroom.
The state contends that O.J. Simpson's attorneys broke a recent California law requiring both sides to exchange information before trial about witnesses they intend to call. It's a legal principle called reciprocal discovery. The defense claims it was an oversight.
I acknowledge when I'm wrong, but there has not been any maliciousness. This is not the most preposterous thing in jurisprudence. This is a mistake. This is a function of dealing with hundreds of witnesses and going to trial in 7 months. This is a function of there being 12 lawyers, 5 investigators, 22,000 pages of evidence. These are slips through the proverbial crack.
Prosecutors ask for a delay in the trial so they can regroup and research the latest disclosures.
It may be a long time before I get home tonight, Your Honor.
The night turns out to be even longer than William Hodgman imagines. That evening, he is rushed to the hospital complaining of chest pains.
Counsel should bear the brunt of his own misconduct, which was willful and deliberate and intentional, and is in effect a thumbing of his nose at this court's order.
In court the next morning, Marcia Clark forges ahead without Hodgman, who is recovering in the hospital. She argues that the defense acted improperly by failing to disclose the identity of already named witnesses.
Legally, it's a violation of 1054 in both spirit and letter of that law, Legally, it's a violation of this court's direct order to counsel, and morally, it's a violation of the jurors' right to the truth. They've been lied to, they've been deceived, they've gotten half-truths from counsel.
This is a stall, Your Honor. Let me finish my opening statement. Why are they so afraid of me addressing this jury and telling them the truth? That's what this is
Cochran
about.
says prosecutors are going too far, trying to gain unfair access to the defense's
Now
case.
they want to get in our briefcases. They like to come home with us if they could. Well, they can't do that. The law does not require that. And so all this stuff, this is much ado about nothing.
For him to turn to us and say we're trying to get into his mind and we're trying to prevent the truth from coming out is outrageous, is disgusting, and is appalling to me as an officer of the court.
Finally, Your Honor, after 7 months, yesterday, somebody spoke up for O.J. Simpson. All across this country in the byways and highways, they heard another side, what this evidence is going to be, and they can't take it.
The law also requires the disclosure of any real or tangible evidence. These disclosures must be made before trial if the witnesses or evidence are then known. These laws exist to promote the ascertainment
Judge Ito
of truth in
decides to
trial.
resume the trial,
To save
but
court
before
time
Cochran can
and to
continue his
avoid the
open,
necessity
the
for
judge
frequent
reprimands the
interruptions and
defense
postponements.
in front of the jury.
During the course of the opening statements, defense counsel mentioned witnesses who had not previously been disclosed to the prosecution or whose written statements were not given to the prosecution before trial as required by law. This violation of the law, this was a violation of the law and one of the causes of the 2-day delay, including the absence of Mr. Hodgman. Keeping in mind that statements by the lawyers are not evidence, you are directed to disregard the comments of defense counsel during his opening statement as they pertain to the following potential witnesses: Mary Ann Gerchis, Michelle Abduram, Mark Partridge, Howard Weitzman, Skip Taft, Christian Reichard. If and when these witnesses are presented to you during this trial, you may consider the effect of this delay in disclosure, if any, upon the credibility of the witnesses involved, and give to it the weight to which you feel it is entitled.
As with all of the evidence, keep an open mind.
On his second go-around, Cochran offers the jury an alibi. At the time prosecutors say the defendant was committing murder, he says O.J. Simpson was at home, hitting golf balls.
10:05 at the Rockingham residence. Mr. Simpson has come outside the house. Mr. Simpson, I think the evidence will show at some point, made a telephone call somewhere between 10 and 10:05 to his then girlfriend Paula Barbieri on a portable phone. After making the phone call at the Rockingham location, we now have Mr. Simpson back inside. Mr. Simpson very often will swing golf clubs, which he keeps all over the place, in his Bentley, in the garage or whatever, I think the evidence will be, and that he sometimes will chip. For you, those of you who are golfers, he'll chip or swing his 4-wood or 3-wood, generally over in this direction over here, where there's some sand where the kids can play and that sort of thing. So during this period of time, Mr. Simpson, at some point, swings his golf clubs or whatever, and at this point and later, chips, so he's out in this yard area after having made the call. After Mr. Simpson has done that and been outside, make his phone call, I think then you'll find the relative positions of the parties. Simpson back inside the residence. The evidence will be he's going to Chicago. At some point he has to pack, get ready. Kato Kaelin's in his room. Rosa Lopez still at her location at that point, although she's just about to leave.
D121.
Same situation at 10:15 at the Bundy location.
D122.
At this location at about 10:15 to 10:20, Rosa Lopez then comes outside of her location to walk her dog again. And she comes out in this general area to the right here on Rockingham. We expect the testimony to be that Rosa Lopez sees the Bronco still parked the same configuration, same location, just like she had seen it between 8:15 and 8:30. She sees it between 10:15, 10:20, the same location. And we think she'll also testify she saw this same Bronco parked in the same manner, same location, same configuration the next morning after she had talked with Detective Fuhrman. And that's Rosa Lopez at 10:20, thereabouts, at Rockingham.
D123.
10:20, contrary to what you've been told, I think by the evidence by the prosecution that they can determine death by the plaintiff will of a dog, we have some live witnesses, Ellen Aronson and Dan Mandel. It's the two that I alluded to earlier who've been apparently on this date to Metzaluna, and they're walking home. They're walking down Bundy from north to south at about 10:20. They walk north to south. This location as I've indicated here. Thank you, Mr. Harris.
D124.
At the other location, at about 10:25, we expect that Rosa Lopez at the Rockingham is certainly going back inside the residence now, having walked the dog. Mr. Simpson inside the residence, Kato Kaelin inside the residence. We're going on back to Bundy.
D125.
Now, by this time, according to what I expect the testimony to be, Ellen Aronson and Dan Mandel have continued walking south on Bundy, and now they are right in front of the residence there at Bundy. Now, the importance of this, we think the evidence will show, that they walked there, this very short distance, right to their right. If the crimes had occurred, would be these bodies, with the gate open, with blood flowing down. If you remember when I read this morning from Phillips's transcript, when he was talking to the coroner about the need to come out there, these bodies are right there. They can be seen from the sidewalk or from the street. So these people are in a rather unique position. I believe that their testimony will be, they saw no bodies, they saw no gate open at that point. It was approximately 10:25 when they're walking at this particular location. So that becomes, they become, as with all witnesses, very important. They become particularly important when the prosecution tries to present a theory that these killings had occurred at 10:15.
After 5 days of delays, Johnny Cochran concludes his opening statement.
In listening to the prosecution's opening statement, they claim that Mr. Simpson left the Rockingham location, traveled to Bundy, killed 2 people with 1 knife, hid the bloody clothes, and returned to Rockingham. He did all this at about 10:15 or 10:15 and got back there at 10:25 or 10:30 or something of that nature. In a short period of time, that's what their theory was. We think that they have further, based upon their opening statement, committed themselves to a theory that in traveling to and from Bundy, Mr. Simpson had used this Bronco that you've heard so much about. So therefore, wherever that Bronco was that night, then according to their theory, that's where Mr. Simpson was that particular evening. What we tried to demonstrate for you in the evidence, we think will show, there's not that window of opportunity. There's not the time in which they can prove that Mr. Simpson committed these horrible crimes. They don't have the time, the opportunity, nor the motive to establish this. We think the evidence will show that he did not, could not, and would not committed these particular crimes.
Point by point, the defense attorney has tried to counter the prosecution's theory that O.J. Simpson murdered Nicole Brown Simpson and Ronald Goldman. But opening statements are not over yet. In an unprecedented move, Judge Lancito allows prosecutor Marcia Clark to respond to information revealed for the first time by the defense.
We will show you a portion of that videotape to demonstrate just what the defendant's physical capabilities really were on the evening of June the 12th, 1994.
She counters their claim that O.J. Simpson was physically incapable of committing the murders by telling jurors about an exercise video the defendant made just 2 weeks before the crimes.
You will see him doing push-ups. You will see him lifting his arms overhead. You will see him stretching, reaching, throwing jabs and uppercuts, and he does that for several minutes in this tape.
Then Clark talks about Marianne Gertjes, an alleged alibi witness, a witness Clark says is a known liar and a Simpson case groupie.
But she somehow never told anyone that she had been on Bundy on the night of the murders, until the time that Robert Shapiro started the hotline requesting that anyone with information come forward and call that hotline number. And it was right around that time that he put out the hotline number that Marianne Gertjes started to say, well, maybe I was driving by that area. Maybe I did see something. Mr. Cochran accused us of not telling you about her, and we didn't, because we didn't know about her.
If the fireworks of opening statements are any indication, the trial of O.J. Simpson will indeed be one of the hardest fought legal battles in recent history. Now, we have seen both sides outline their respective cases. And next, prosecutors will call witnesses and present evidence that they hope will prove beyond a reasonable doubt that O.J. Simpson killed Ronald Goldman and Nicole Brown. And then later on, we'll hear from the defense, whose job it is to raise reasonable doubt in the minds of the jury. For Court TV in Los Angeles, I'm Greg Jarrett.
O.J. Simpson murdered Nicole Brown and Ronald Goldman.
Prosecutors say Simpson had the motive.
He killed her because he couldn't have her.
They say he had the time.
Did you see the defendant at 10:15?
No.
They say they have the proof.
After coming out into the driveway and finding the blood trail, he became a very strong suspect.
But defense lawyers claim
That O.J. Simpson is an innocent man, wrongfully accused.
from Los Angeles, the O.J. Simpson trial, the prosecution's case.
Here in downtown Los Angeles, prosecutors are about to present their case against O.J. Simpson. Hello, I'm Greg Jarrett. Prosecutors have promised solid, conclusive, albeit circumstantial evidence that O.J. Simpson killed Nicole Brown and Ronald Goldman. But without a murder weapon, an eyewitness, or even a confession, is the evidence strong enough to convince the jury beyond a reasonable doubt that this hero on the football field and the movie screen is, in fact, a murderer? Prosecutors begin by introducing evidence that O.J. Simpson may have abused his ex-wife. But is the fact that he allegedly beat Nicole evidence that he killed her?
911 emergency, operator 461. Hello?
The frantic call from Nicole Brown Simpson in the early morning hours of New Year's Day 1989 was taken by this 911 operator, the state's first witness, Sharon Gilbert.
She was beat up.
Detective John Edwards was the first police officer to find Nicole.
She said that O.J. had slapped her, hit her with his fist, and kicked her.
O.J. Simpson pleaded no contest to one count of misdemeanor spousal abuse. Simpson was ordered to do 120 hours of community service and undergo counseling.
911 emergency.
Nicole Brown Simpson called 911 again in October of 1993.
He's back. Please. Okay, what does he look like? He's O.J. Simpson. I think you know his record.
Ron Shipp, a friend of O.J. and Nicole Simpson, counseled them on domestic violence. Shipp says he stood by Simpson after the murders, but now must put his friendship aside.
Do you and the defendant remain friends today?
Well, I still love the guy, but I don't know. I mean, this is a weird situation I'm sitting here in.
Shipp tells the jury of a conversation he says he had with the defendant in Simpson's bedroom the night after the murders.
He kind of jokingly just said, you know, to be honest, Shipp, that's what he called me, Shipp. He said, I've had some dreams of killing her.
It is a chilling revelation, one that the prosecution claims is evidence of O.J. Simpson's guilty state of mind.
Isn't it true, sir, that
On cross-examination, though, defense attorney Carl Douglas suggests that Shipp took the stand to boost his sagging acting career.
you do realize, Mr. Shipp, that by testifying as you have, you are going to enhance the name of Ron Shipp around the world?
But that's not why I'm doing this, Mr. Douglas. I'm doing this for my conscience and my peace of mind. I will not have the blood of Nicole on Ron Shipp.
After more questions from Douglas, Shipp speaks to the defendant directly.
This is sad, O.J., but no, this is really sad.
Your Honor, I move to strike that.
Judge Lancido instructs the jurors to disregard Shipp's comment to the defendant. but some damage may have been done.
Denise Brown.
She is the older sister of Nicole Brown Simpson, and she has stated publicly that she believes O.J. Simpson murdered her sister. Denise Brown remembers some especially ugly behavior by her former brother-in-law.
O.J. grabbed Nicole's crotch and said, "This is where babies come from, and this belongs to me." Picked her up, threw her against a wall. Picked her up, threw her out of the house. I used to call her a fat pig.
Brown speaks of the day her sister died and what she calls O.J. Simpson's bizarre behavior at his daughter Sydney's dance recital just hours before the killings.
He had a very far-away look. It was actually really kind of spooky. It was a frightening look.
And then, the last time she saw Nicole.
We kissed each other goodbye. The last thing I told her was that I loved her.
During the time that...
Defense attorney Robert Shapiro adopts a gentle tone with Brown. Nevertheless, he tries to discredit her recollection of Nicole's abuse.
At that time, were you also still drinking?
Oh, I was drinking at that time, yes.
And how would you describe your consumption of alcohol?
I said I had a problem.
Shapiro assails Brown's characterization of her brother-in-law's demeanor at the recital by introducing a home video. Taken by a passerby, it shows O.J. Simpson kissing his former in-laws goodbye and seeming to be in good spirits. Look closely as the jurors will at this piece of evidence. Is that a man contemplating murder? Prosecutors shift their focus from allegations of domestic abuse to their theory of when and how the killings occurred. And remember, Prosecutor Marcia Clark in her opening statement told the jurors the killings took place at around 10:15 on the night of June 12, 1994, and the state claims there was plenty of time for O.J. Simpson to have killed two people, change out of his bloody clothes, and get home by 11 o'clock. The defense says that O.J. Simpson was at home and that the state has twisted the time to fit its case.
We will be offering.
Prosecutors try to fix the time the victims left the Mezzaluna restaurant, where Ronald Goldman worked and Nicole Brown Simpson ate her last meal.
Ms. Gavin, directing your attention to the date of June the 12th, 1994. As of that
They
date,
call witnesses who testify that Nicole Simpson left at about 8:45. They say Nicole called Goldman later, asking him to bring to her home a pair of eyeglasses left behind.
He left at about 10 minutes to 10.
What happened in the next 25 to 30 minutes is not accounted for. At 10:15 to 10:20, Pablo Fenves, a neighbor of Nicole Brown Simpson's, says he heard a barking dog.
It was it was fairly persistent. It was at a significant pitch, and as you may recall, I described it at the time as a plaintive wail. It sounded like a, very unhappy animal.
That unhappy animal turned out to be Nicole's Akita, Kato. Prosecutors contend the barking began at about 10:15, when Nicole and her friend were murdered.
My name is Stephen Schwab. That's
Another neighbor walking his dog that night came upon the Akita. He says it was around 10:55.
The first thing I saw was some blood on one of the back paws.
A third neighbor, Sukru Bustepi, volunteered to keep the dog for the night. But the dog became so agitated that before midnight, he and his wife took the dog for a walk. The dog stopped at 875 South Bundy, Nicole Brown Simpson's condominium.
Can you tell us what you saw?
I saw a lady laying down, full of blood.
We observed a female white in a black dress laying in a puddle of blood. We discovered the body of a male white laying against the north fence. There's an envelope and a dirt, a glove, and what appears to be a knit cap. There was paw prints towards the sidewalk.
Bloody shoe sole prints on the ground.
motorcade has left the criminal courthouse in downtown Los Angeles.
The focus of the state's case against O.J. Simpson shifts to the crime scene. The entire trial goes on the road.
That one right here.
So the jury can see 875 South Bundy Drive, where Nicole Brown Simpson and Ronald Goldman were murdered.
We got a problem. We got a problem where these guys are set up.
Little escapes the watchful eye of lead prosecutor Marsha Clark or the other prosecutors Christopher Darden, Hank Goldberg, and Sherry Lewis. O.J. Simpson's attorneys wait to go inside. A handful of reporters cover the excursion.
The dimensions of the pathway from the sidewalk to where Nicole Brown Simpson's body was found, it looks even smaller. The area where Ron Goldman's body was found looks even smaller.
At Rockingham, that's the very first opportunity we had of seeing O.J. Simpson. He seemed very, very animated, pleased apparently to be home.
If convicted, this could be O.J. Simpson's last trip home. Back in court, testimony resumes. O.J. Simpson is seemingly disturbed by the state's exhibits, grisly photographs of the victims' bodies left in a bloody courtyard.
This is one of the photographs that's
Because the photographs are explicit, Judge Lancito prohibits the media from showing them.
You never thought about the possibility that you were obliterating footprint evidence as you walked?
Was evidence trampled, contaminated, missed, or planted, as the defense says it was? Did police frame O.J. Simpson or botch the investigation? These are the questions that Marsha Clark must tackle as she steps her police witnesses through what the state calls a by-the-book investigation. Detective Ron Phillips arrived at the crime scene at 2:10 a.m. He says it was his job to tell O.J. Simpson his ex-wife had been killed.
I think the first words out of his mouth were something to the effect, "Oh my God, Nicole is killed," or "Oh my God, she's dead."
Did Mr. Simpson ask you how she was killed?
No,
Did he ask you when she was killed?
no,
Did he ask you if you had any idea who had done it?
no,
Did he ask you where it had occurred?
no,
Did he ask you anything about the circumstances of how his ex-wife had been killed?
no.
The prosecution's case against O.J. Simpson is a circumstantial one. There are no eyewitnesses to the killings, no confession from the defendant, and no murder weapon.
Showing it to you now.
And so gloves, blood, time, motive, and a ski cap form the crux of the evidence from which the state will ask jurors to deduce Simpson's guilt. The detective called to identify many of the items found at the crime scene is Tom Lang. He says the evidence pointed to one suspect, O.J. Simpson.
Did you formulate a theory as to whether or not this murder was perpetrated by one or two people?
Yes,
And what was that theory, sir?
it was perpetrated by one person.
And what is that based on?
I observed one distinct set of bloody shoe prints between both victims, leading away from both victims west on the sidewalk, away from the location. Both victims were killed in a similar manner, slashing and stabbing wounds. Both victims had their throats slashed.
But the chief detective is challenged by Chief Defense Attorney Johnny Cochran.
You don't turn a blind eye on evidence just because it might point toward Mr. Simpson's innocence, do you?
Cochran says Lang ignored leads, suggesting that Nicole Brown Simpson and Ronald Goldman were accidental victims of irate drug dealers out to kill the real target, Faye Resnick. Resnick was living at Nicole's and taking drugs around the time of the murders. Infuriated by Cochran's suggestion that the killings were drug-related, Christopher Darden interrupts Judge Lancito during a sidebar conference.
Mr. Darden, let me give you a piece of advice. Take about 3 deep breaths.
The judge cites him for contempt, and Darden apologizes.
It appears that the court is correct, that perhaps my comments may have been or are somewhat inappropriate. I apologize to the court. I meant no disrespect.
On redirect examination, Marsha Clark retaliates against the allegation of drugs.
Were the murders of Ron Goldman and Nicole Brown drug-related murders?
I do not believe they were.
Please tell us why.
Usually there will be evidence of narcotics usage or sales at the locations.
Did you find any evidence of drug usage or sales at 875 South Bundy?
No.
My first and only witness today, I hope Your Honor, will be...
Then something highly unusual occurs. Rosa Lopez, the former housekeeper of O.J. Simpson's neighbor, is called to testify for the defense, a jarring disruption for the state. Johnny Cochran says Lopez must testify now because she's about to leave the country for her native El Salvador. He says she provides O.J. Simpson with a possible alibi. Lopez tells Cochran outside the jury's presence she saw O.J. Simpson's white Ford Bronco parked outside his home on Rockingham Avenue as she walked her employer's golden retriever at about 10:15 on June 12, 1994, the time that prosecutors say O.J. Simpson was at his ex-wife's home committing double murder.
That I wanted to leave. I don't want to be here any longer.
If Rosa Lopez is O.J. Simpson's most important witness, she is perhaps his most problematic one as well. She cannot recollect other details of the night.
What month was this?
¿Y en qué mes fue esto?
No me recuerdo, señor.
I don't remember, sir.
Was it in August?
¿Fue en agosto?
Yo no me recuerdo, señor.
I don't remember, sir.
Was it during the summer?
¿Fue durante la temporada de verano?
No me recuerdo, señor.
I don't remember, sir.
And the defense has more problems. Marcia Clark complains that defense attorneys violated the law by failing to disclose a tape-recorded statement by Lopez.
Of the court, they should be ashamed. They should be embarrassed. In fact, their bar tickets should be hanging in jeopardy at this point for this kind of misconduct. And this is misconduct.
Defense attorney Gerald Ullman apologizes for the lapse.
Today, Your Honor, seems a particularly appropriate day for the defense to appear in sackcloth and ashes.
For Mr. Yeoman to stand before this court and attempt to avoid the sanctions that are sorely needed in this case by saying he wears sackcloth and ashes should be unavailing and unimpressive to this court. Frankly, I don't care if he wears a dress.
All right, good luck, Miss Lopez.
After a week of wrangling and finger-pointing, O.J. Simpson's most important witness gets to go home. But questions remain. Will the jury ever see Rosa Lopez's tape-recorded testimony? And if they do, will her story stand up amidst inconsistencies in her testimony? When prosecutors resume their case, cameras are waiting outside.
What we're seeing today with the media coverage and the spectators at the courthouse is more than even on the opening day of this trial.
I do.
Detective Mark Fuhrman, the man the defense branded as a racist who they claim may have framed O.J. Simpson, takes the stand. Marcia Clark moves quickly to humanize the 19-year veteran of the Los Angeles Police Department.
Detective Fuhrman, can you tell us how you feel about testifying today?
Nervous? Reluctant?
Can you tell us why?
Throughout, since June 13th, it seems that I've seen a lot of the evidence ignored and a lot of personal issues come to the forefront. I think that's too bad.
The personal issues Fuhrman speaks of are claims that he harbors racist views, claims repeated on national television.
He said he'd gather all the niggers together and burn them.
Key to the accusation of racism is Kathleen Bell, who claims that Fuhrman uttered these slurs a decade ago. Bell kept quiet until she sent this letter to the defense. In it, she writes that Fuhrman told her, quote, when he sees a nigger driving with a white woman, he would pull them over, end quote. And if he didn't have a reason, he would find one. Ironically, the letter is introduced by Marcia Clark first, in an effort to take out some of the sting from what is certain to be a brutal cross-examination.
Did the conversation Kathleen Bell describes in this letter occur?
No, it did not.
Detective Fuhrman testifies that he and 3 other detectives drove to O.J. Simpson's home to inform him his ex-wife had been killed.
Do you recognize the vehicle that's being shown to you in this photograph, sir?
Yes, that appears to be the vehicle that I saw parked by the Rockingham gate that morning. I noticed that it was just parked just a little askew, a little strangely.
Fuhrman also says he noticed a small spot above the driver's side door handle.
I looked at it and it looked reddish, brown and translucent qualities to it, and it appeared to be dried blood. We had previously discussed our concerns with another possible victim or a kidnap type robbery, murder-suicide. We had no idea.
Defense attorney F. Lee Bailey, who will cross-examine Fuhrman, watches the examination unfurl without objection.
Then I walked.
Fuhrman explains that he hopped a wall and let the other officers in. Once inside Simpson's property, Fuhrman says he awakened a disoriented and disheveled Brian Kato Kaelin. Fuhrman asked Kaelin if anything unusual had happened the night before.
He said he heard a crash or a thump on his wall. He thought there was going to be an earthquake.
That sparked him to search for clues along the path behind Kaelin's bungalow.
I continued walking down the path, and when I got approximately 15 or 20 feet away, I saw a dark object. It appeared a dark leather glove. It appeared to be somewhat moist or sticky.
That sticky right-hand glove, Fuhrman tells Clark, appeared to match the left-hand glove found at Ron Goldman's feet.
Thank you, sir. I have nothing further.
So far, Mark Fuhrman has portrayed himself as a cop just doing his job, not the racist that Simpson's attorneys say he is. But the detective is about to face his accuser, F. Lee Bailey.
Now, did you experience any disappointment whatsoever when Phillips told you you were being removed from this murder case?
Did I show any disappointment?
Any disappointment whatsoever? Did you experience any?
Well, I was disappointed we lost the case.
Sure. Did it go a little further than that, Detective Fuhrman?
No, not at all.
Weren't you a little bit angry that you were being shoved out of a murder in your own territory?
No.
Didn't bother you a bit?
None.
Weren't you a fellow that had spent a good part of his career waiting for an opportunity to make, quote, the big arrest?
No.
Bailey implies that Fuhrman had ample reason to frame O.J. Simpson.
How about a couple of gloves, Detective?
Excuse me?
Did you see a couple of gloves up there?
No, I saw one glove.
And that he did so by taking a glove from the crime scene to O.J. Simpson's estate.
Did you wipe a glove in the Bronco, Detective Fuhrman?
No.
You did not?
No.
When you went out to where the glove was eventually pointed out to the other detectives, how long did you spend there before you went back to talk to them?
10, 15 minutes, totally.
What did you do for 10 to 15 minutes on that scene?
Look for a victim or a suspect.
F. Lee Bailey has, in a way, put Mark Fuhrman on trial. Then, in front of the predominantly black jury, Bailey confronts Fuhrman with the allegations of racism.
I want you to assume that perhaps at some time, since 1985 or 6, you addressed a member of the African American race as a nigger. Is it possible that you have forgotten that act on your part?
No, it's not possible.
Are you therefore saying that you have not used that word in the past 10 years, Detective Fuhrman?
Yes, that's what I'm saying.
And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Fuhrman?
That's what I'm saying, sir.
So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Fuhrman?
Yes, they would.
All of them, correct?
All of them.
After 3 days of heated cross-examination, Judge Lance Ito's courtroom is tense, both from F. Lee Bailey's exchange with Mark Fuhrman and with lead prosecutor Marcia Clark. Several times it gets nasty.
Officer of the court, he has lied to this court. He is impeached by his own witness.
I ask that you put a stop to it.
The war of words escalates when Bailey tries to introduce another pair of gloves, ones he bought at Brooks Brothers.
Out that if Miss Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory.
This has no part in any search for the truth. This is a fantasy woven by the defense.
Clark says Bailey's gloves don't match the gloves in this case.
Size small. I guess it's Mr. Bailey's.
My name is Philip Van Adder.
Philip Van Adder, one of the lead detectives investigating the double murder, is called to the witness stand. Christopher Darden turns immediately to the bloody left-hand glove found at Ron Goldman's feet.
How many gloves did you see then?
One.
You ever see two gloves at this location?
Not at Bundy, no.
The detective tells Darden he accompanied Mark Fuhrman to O.J. Simpson's estate at 360 North Rockingham Avenue.
What did you see?
A brown leather man's right-handed glove.
What is shown in 116E?
That's the original location and the glove that was pointed out to me that morning. He became a suspect as soon as I saw the glove. And then, after coming out into the driveway and finding the blood trail, he became a very strong suspect. Seeing what appeared to be another blood trail, I walked to the Bronco to have a closer look at the Bronco to see if there was any other blood I could see there. I looked in from the passenger side of the vehicle and observed what appeared to be a blood smear along the passenger side of the console and what appeared to be blood on the inside of the driver's door of the vehicle.
You ever see anyone wipe a bloody glove around inside that vehicle?
No.
Now, after you returned from the Bronco, did you follow the apparent blood drops?
I did, yes, sir.
And where did they lead you?
Well, I ultimately determined that they led me right into the residence.
Right through the front door?
Right through the front door, that's correct.
Detective Van Adder questioned Simpson at police headquarters the day after the killings.
It appeared that he had an injured knuckle on the left middle finger of his left hand.
Did you consider that significant at all?
Oh, I certainly did, yes. He had the injury that was that would have caused those blood drops on the left side of the bloody footprints.
And Van Adder says Simpson's injury was the source of blood drops on the driveway and the foyer of his Brentwood estate. Prosecutors speculate Simpson injured his knuckle in the struggle with Ron Goldman.
Told us that you took or had a nurse take a sample of the defendant's blood. Is that right?
Yes.
Christopher Darden has a vital interest in establishing what Detective Van Adder did with the sample of O.J. Simpson's blood.
I maintained custody of the blood sample and turned it over to the criminalist.
And where was the criminalist when you turned it over to him?
He was at Rockingham finishing the work there with the search warrant.
Defense attorneys have hinted that police conspired to plant O.J. Simpson's blood on evidence in an effort to frame him for murder.
Your Honor, it is not on video, it's on laser.
Darden tries to discredit yet another defense theory, that O.J. Simpson did not have enough time to commit the murders.
I'm Detective Van Adder again.
Darden introduces a videotape of the detective driving back and forth between the crime scene and O.J. Simpson's estate.
In the video here, it took you 5 minutes and 22 seconds to drive from Bundy to Rockingham?
Yes.
Plenty of time, Darden claims, for Simpson to commit murder at 10:15 and return home by 11 o'clock.
Good afternoon, Detective.
Good morning, Mr. Shapiro.
After an awkward start, Robert Shapiro summons his client to the jury box.
Mr. Simpson.
The ex-football player parades his middle finger before the jury, the same finger Van Adder says was swollen from the cut the day after the murders. The defense wants to show that Simpson's arthritic knuckle has always been swollen and remains so today. Robert Shapiro wears a blue ribbon pin in his lapel, a pin that signifies support for the police. Nevertheless, he attacks the veteran detective. Shapiro suggests the vial of Simpson's blood was, in essence, missing for a while.
Isn't it true that the only accounting for time that is recorded is the time the blood was drawn, which you say is 3:30, and the time that you logged in at Rockingham, which is 5:20, almost 2 hours?
That's correct, yes.
The defense implication? In those 2 hours, police officers had enough time to plant O.J. Simpson's blood on the evidence.
People call Mr. Kaelin?
Kato Kaelin, the part-time actor who played a role in the lives of O.J. Simpson and Nicole Brown Simpson, takes the witness stand. Kaelin is both a friend of the defendant and a witness essential to the timing of the state's case. He was the last person to see O.J. Simpson before the killings and one of the first to see him afterwards. On direct examination, Marcia Clark asks Kaelin if he moved into O.J. Simpson's poolside bungalow to further his acting career.
I was hopefully getting things on my own. But
So
you know, if he'd bring it up on his own. I don't think we're going for the same parts. I don't.
Clark then turns to the serious matter at hand, the night of the murders. It was 9:10, Kaelin recalls. He and Simpson drove in the defendant's Bentley to McDonald's for hamburgers and French fries.
What was he wearing at that time?
At the best of my recollection, I thought it was a sweat outfit.
Okay, what color was it?
Dark color.
As the defendant drove, sir, were you able to see his hands?
Yes.
See any injury to them?
No.
Any bleeding from either hand?
No.
Kaelin says that the two returned around 9:35. Kaelin headed to his bungalow, ate his French fries, and, a while later, called a friend.
Yes.
During that phone call, sir, did something unusual occur?
Yes.
And what was that?
I heard a thumping noise.
How many thumps did you hear?
Objection.
Overruled.
Yes.
3.
Can you demonstrate for us how loud it was?
Somewhat, yes.
Go ahead. Yeah, go ahead.
That noise, Kaelin recalls, sounded around 9:40. It came from the back wall of his guest house, along the path where Mark Fuhrman said he found a bloody glove. Prosecutors contend the noise was O.J. Simpson returning home after the killings.
I thought it could be someone.
So Kaelin investigated. On his walk around the property, he says he spotted a limousine parked outside. Kaelin buzzed it in.
You saw the defendant?
Okay, so all three of us, yes. OJ, myself, and the driver.
Where was he?
Just like outside on the driveway.
That was at 11 o'clock. Kaelin says he loaded a golf bag into the limousine and reached for a knapsack, but Simpson called him off.
You offered to get it?
Yeah.
And what was his response?
He'll get it.
What did he say?
I'll get it.
That knapsack has never been seen since. Prosecutors theorize that O.J. Simpson stuffed his bloody clothes and knife in it, then threw it away. Marcia Clark concludes her examination by returning to the subject of time.
Did you see the defendant at 9:45?
No.
Did you know where he was at 9:45?
No.
Did you see the defendant at 10:15?
No.
Did you know where he was at 10:15?
No.
Did you see the defendant at 10:50?
No.
Did you know where he was at 10:50?
No.
I have nothing further.
When you're a limo driver, you're set pretty much on schedules. So you're looking to see if you're on time.
Keeping track of time is Alan Park's stock in trade and why he is a critical witness for the state. Park picked up O.J. Simpson at his home on June 12, 1994, and drove him to the airport. But he says that when he arrived at 875 Rockingham Avenue, he did not see Simpson nor his Bronco.
Was that white Bronco there at the time you drove by at about 10:22?
I didn't see it.
At 10:25.
No, I didn't.
At 10:39.
No, I didn't.
Asked what time he last used his Bronco, Simpson told police, quote, 8-something, 7, 8, 9 o'clock, I don't know, right in that area.
Yes.
Can you tell us if that appears to be the size of the person that you saw enter the front entrance of the house at Rockingham?
Oval. Yes, around the size.
Park says that at about 10:55, he saw a 6-foot, 200-pound black person in dark clothing enter O.J. Simpson's house.
What did you do?
That's when I got back up and out of the car and rang the intercom. This time there was an answer, which was Mr. Simpson. He told me that he overslept and he just got out of the shower and he'd be down in a minute.
And what happened next?
5 minutes later, he tells Clark, Simpson walked out wearing stonewashed jeans and a white shirt.
About this size.
Park remembers seeing 4 travel bags near the front door and a 5th bag on the driveway.
Kato offered to go get the bag, and he said, no, that's okay, I'll get it.
All right, Mr. Williams, come forward.
At the airport, a skycap named James Williams checked Simpson's bags through to Chicago.
How many bags did the defendant have, sir?
Just the 3.
The 2 you checked and the 1 he carried?
Yes.
That's 2 fewer bags than Alan Park said he saw at Simpson's home half an hour before. Park testified earlier that he saw a black duffel bag atop a trash can by this skycap station with Simpson standing nearby.
I saw it from a distance.
This is the clearest suggestion yet of how prosecutors think O.J. Simpson disposed of both the knife and blood-soaked clothes. With the appearance of Dennis Fung, a criminalist at the Los Angeles Police Department, the focus of the case shifts again from Simpson's whereabouts on the night of the murders to the manner in which the physical evidence was collected and preserved.
We have some new attorneys present in the courtroom.
Marcia Clark introduces new prosecutors.
This is Mr. Hank Goldberg.
Good morning.
And this is Mr. Woody Clark. And this is Mr. Rock Harmon.
Much is at stake for these lawyers who contend that O.J. Simpson's blood is at the crime scene and the victim's blood is in his car, in his home, and on his property.
My name is Dennis Fung.
But the integrity of the blood evidence rides on the witnesses who handled it.
We have 3 lawyers who will be assisting us in this phase of the evidence.
Peter Neufeld, Robert Blazier, and Barry Scheck argue the criminalists made so many mistakes that the evidence they collected is invalid.
Looking at the photograph.
Dennis Fung explains that the day after the killings, he and his assistant, Andrea Mazzola, lifted dozens of blood spots from O.J. Simpson's Ford Bronco, from the ground near O.J. Simpson's car, from Simpson's driveway, and from the foyer of his home.
And within the bag is a glove. And does that appear to be the item that you retrieved from the Rockingham location? Yes, it is.
Anticipating defense arguments that police, out to frame Simpson, doused evidence with his blood, Fung testifies that all the blood collected the day after the murders was already under lock and key by the time Detective Philip Van Adder handed him Simpson's blood sample. Hank Goldberg tries to diffuse 2 more points the defense will surely bring up on cross-examination. 1. Did the criminalist take care not to contaminate the evidence?
When you are at a scene, do you wear the same pair of gloves throughout the entire scene? No. When the gloves get dirty or I have to use some of my instruments or personal items, I will remove the gloves so as not to contaminate myself or other items of evidence.
And did junior criminalist Andrea Mazzola wield responsibility at the crime scene beyond her expertise?
When I found out that it was a high-profile case and it was going to be a complicated scene, I decided that she should, in a sense, take the back seat.
And that testimony wasn't accurate, was it?
That I personally did all that stuff? No.
Right. You did not tell the grand jury that Andrea Mazzola was the one that picked up the hat and picked up the glove, right?
That's correct.
On cross-examination, Barry Scheck implies that Fung wanted to hide Mazzola's role in the case because she was inexperienced.
Would it be fair to call her a rookie in processing crime scenes?
Sustained. There have been rookies of the year who've been MVPs.
Sure thing. Well, would you call her a novice? Entry level? Is that, how about that?
Yes.
Scheck moves from Mazzola's experience to the decision by more senior officers to cover Nicole Brown Simpson's bloody body with a blanket from her own home.
Assuming that Mr. Simpson had been in the Bundy residence, had sat or lay on that blanket, shed hairs on that blanket, and that blanket was taken, put in the middle of this crime scene, could that, in your expert opinion, be a source of secondary transfer of his hairs to the crime scene?
It's possible.
Possible?
Yes.
All right. And that would be what is known as contamination of the crime scene.
Yes.
That's a terrible mistake from the point of view of a criminalist, isn't it?
Yes.
Thus far, Dennis Fung has been asked questions on cross-examination that have vilified the work of his fellow officers. But now Barry Scheck points his finger squarely at Fung, accusing him of infecting certain evidence by handling it with his bare hands.
How about that, Mr. Fung?
Is that a question, Mr. Scheck?
Yes. How about that picture, Mr. Fung? Does that refresh your recollection that you took the envelope from Andrea Mazzola with your bare hand?
When you pointed out the time frame, it makes it even more sure in my mind that that is not the envelope, because we did not start picking up envelope or evidence until well after the coroners were gone.
Next, Scheck asks the witness about O.J. Simpson's blood sample that Fung said he received from Detective Van Atter the day after the killings.
What they call card transaction
Scheck
reports
reads the
indicating
witness
who
his
was in and
earlier
out of the
testimony.
evidence process.
Fung testified under oath that the last thing he did at Simpson's estate was accept a gray envelope containing a vial of Simpson's blood.
Okay, let's roll it here.
Scheck introduces a videotape of Fung at Simpson's home that appears to catch him in a bold-faced lie.
You do not have a gray envelope in your hands.
That's correct.
You do not have a brown paper bag in your hands.
That's correct.
You do not have a posse box in your hand.
That's correct.
My question to you, sir, is simply, you knew when you saw those videotapes that you could not have carried the gray manila envelope in the posse box and put it in the back of the crime scene truck, yes or no?
That, I came to that conclusion by watching that, yes.
The implication? Dennis Fung is covering for the police, who the defense says planted blood on the evidence to frame O.J. Simpson for murder.
There. Stop.
Damage control. Hank Goldberg introduces yet another video, one that was taken by a news crew after the defense's video was shot. Look closely. The state's video shows Fung with something that resembles an envelope in his hand.
Were you involved in some kind of a conspiracy with Andrea Mazzola to cover up receiving some item with your bare hands?
No.
Were you involved in any conspiracy with Detective Van Atter to allow him to keep a vial overnight so that he could do with it what he pleased?
No.
Mr. Fung, have you ever testified before in a case where you were on the witness stand for 8 days?
Never.
Are you going to be glad to be off?
Very.
Okay, thank you. Nothing further. Thank you.
All right, ladies and gentlemen.
But as Dennis Fung leaves, something unexpected and bizarre happens. O.J. Simpson and his lawyers shake hands with Dennis Fung. If the jury believes the defense that mistakes made in collecting the critical blood evidence render it unreliable, the state's case could be in jeopardy. Prosecutors are about to present their best evidence, the DNA results, which they say directly and conclusively link O.J. Simpson to the murders of Nicole Brown Simpson and Ronald Goldman. What is DNA? The letters stand for deoxyribonucleic acid, and no two people except identical twins have the same DNA.
DNA is the blueprint molecule, the chemically coded information that carries a person's hereditary information, what they are, what they look like, their individuality.
More than 99% of DNA is the same for everyone, but a small portion of the DNA molecule varies dramatically among individuals. And it's this region that is tested to distinguish one person from another. Since 1987, DNA testing has been used to match blood and other genetic material found at a crime scene to a suspect. There are two basic kinds of DNA tests.
PCR, 3 letters that stand for polymerase chain reaction. Big word, pretty easy. It's a copying process where a relatively small piece of DNA is copied. RFLP, restriction fragment length polymorphism analysis, is done with special enzymes that we call restriction endonucleases, which act like molecular scissors. They will clip out, if you like, a piece of DNA that we're interested in so that we can then analyze it.
The PCR test provides less information than RFLP testing and is often used to eliminate a suspect rather than convict. RFLP requires a larger sample and is more definitive. But just how definitive is it?
Dr. Robin Cotton, please. All right, Dr. Cotton.
Prosecutors call their first expert in DNA identification. Robin Cotton is the director of Cellmark Diagnostics, one of the firms which perform DNA testing on blood samples from the murder scene, from O.J. Simpson's Ford Bronco, and his home.
And the other strand.
Cotton, who has a Ph.D. in molecular biology and biochemistry, begins by giving the jury a crash course in DNA.
Dr. Cotton, who are you?
Then, guided by prosecutor George Clark, Dr. Cotton delivers the most damning testimony against O.J. Simpson yet.
Is Mr. Simpson then included as a possible donor of that blood stain?
Yes, he is.
What about Mr. Simpson?
They do not exclude him. Nicole Brown and Ronald Goldman are excluded, and Mr. Simpson is included as a possible donor.
Drop by drop, Dr. Cotton reveals that O.J. Simpson's DNA matches the DNA in blood drops leading away from the victims at the murder scene. How certain is she? For one of the blood drops,
That set of characteristics would occur in approximately 1 in 170 million individuals.
and what about a blood-spattered sock that investigators say they found in O.J. Simpson's bedroom? Cellmark tested it and found
Nicole Brown is not excluded. She has 8 bands, and they are consistent and in similar positions to the DNA bands that are found on the sock.
Dr. Cotton tells the jury that the chance the blood on the sock is anyone other than Nicole Brown's is 1 in 6.8 billion to 1 in 530 billion. The population of the world is about 5.4 billion.
NRC report.
Prosecutors say these statistics add up to guilt beyond a reasonable doubt. But defense attorney Peter Neufeld says doubt is the only thing that is reasonable.
Well, would you agree, Dr. Cotton, that if someone was falsely implicated by an RFLP DNA test, it would much more likely be due to sample handling error or cross-contamination rather than due to a coincidental match between people with the same RFLP profile?
Yes, sure.
Now, your laboratory has had at least a couple of instances where you had false matches due to sample handling error and cross-contamination. Isn't that correct?
Yes, 2.
Dr. Cotton admits that Cellmark made other prior errors. But does that mean the state's best evidence against O.J. Simpson cannot be trusted? Attorneys for the state call yet another expert in DNA. Gary Sims is the chief forensic analyst at the California Department of Justice. He tested the glove allegedly found at O.J. Simpson's estate and tells prosecutor Rockney Harmon it has Ronald Goldman's blood on it.
Visually, were you able to determine that that stain appeared to match one of the reference samples?
Yes, it does.
Now, which one is that?
That would be the sample from Goldman.
From Ronald Goldman?
Yes.
Sims says the statistical chances the blood is anyone other than Goldman's is 1 in 1.2 billion to 1 in 41 billion, and that this glove also has a mixture of the defendant's and both victims' blood on it. Sims also tested blood smears found inside O.J. Simpson's Ford Bronco. Blood on the instrument panel matches the defendant. Blood on the steering wheel matches Nicole Brown Simpson and the defendant. And blood on the center console matches the blood of both the victims and the defendant.
That's correct.
Sims' most stunning finding further supports Dr. Cotton's conclusion that Nicole Brown Simpson's blood was on the rumpled sock at the foot of O.J. Simpson's bed. He says that the chance the blood belongs to anyone other than Nicole Brown Simpson is 1 in 7.7 billion to 1 in 41 billion.
You do not hold yourself out to this jury.
But on
as an
cross-examination,
expert in statistics
defense attorney Barry Scheck sounds a familiar refrain. O.J. Simpson is an innocent victim of evil police officers who either intentionally manipulated the evidence or through clumsy handling rendered it unreliable.
Mr. Sims, you are not part of any conspiracy to tamper with evidence in this case,
No.
are you?
No, I'm not.
To your knowledge, Dr. Cotton from Selmark is not part of any conspiracy to tamper with evidence in this case.
Irrelevant cause for speculation.
Overruled.
No, I don't believe she is.
But Mr. Sims, as you sit here today, you don't know how and you don't know when that blood got on the sock, do you?
Objection, that's argumentative.
Phrase the question.
Do you know, from your own personal knowledge, how and when that blood got on the sock?
No.
Again and again, the defense has raised questions about the validity of the state's evidence. But the most important question is, what will the jury believe?
We indicated to you that there would come a time when we may have to show you some photographs and some diagrams about matters that are not pleasant to look at.
The grisly way in which Nicole Brown Simpson and Ronald Goldman died takes center stage of the state's case. But before the testimony can get underway in earnest, the trial is thrown into turmoil.
Judge Lance Ito dismisses 2 more jurors from the trial of O.J. Simpson, and the case is once again thrown into turmoil as the defense appeals, and a mistrial looms ever larger.
It became necessary for me to...
From the early days of the trial, Judge Ito has been plagued with problems surrounding the jury.
The court has found abundant good cause to excuse juror number 602.
Would you be willing to make any kind of statement at all?
The dismissal of jurors came at a pace of more than 2 a month. One dismissed juror is writing a book. One was outspoken about the problems on the jury.
There are racial problems, and the deputies, some of them, not to badmouth the sheriff's department, but some of them are promoting it.
And one said she just couldn't take it anymore.
No comment at this time.
These extraordinary allegations in the middle of the trial caused delays and investigations. But despite the shrinking pool of jurors, the trial of California versus O.J. Simpson pushes on.
Yes.
Brian Kelberg, another lawyer from the district attorney's office, will question Los Angeles County's chief medical examiner about what the autopsies of the victims revealed.
In this manner.
Dr. Lakshmanan Satyavagishwaran says Nicole Brown Simpson was knocked unconscious with a blunt object and fell to the ground. He speculates that the killer then attacked Ronald Goldman and came back to kill Nicole.
She was most likely face down when the final fatal stab incise wound was inflicted.
Nicole Brown Simpson's throat was slashed so deeply that the murder weapon nicked her spine.
I would say she died within a few minutes, probably much less than a minute or so.
Ronald Goldman also died within minutes.
There's been some movement as any penetration could have taken place.
But not before the murderer tortured him by running a knife across his neck.
It would be like some kind of threatening cuts.
Slashed and stabbed him more than 24 times, and made 5 small puncture wounds to his cheek.
After the fatal injuries were inflicted, it could have been inflicted to check whether he was still alive or not. That would be one conclusion I would draw also.
The murders of Nicole Brown Simpson and Ronald Goldman were swift and savage, and the photographs so graphic that at least 2 jurors walked out of court. But on cross-examination, Robert Shapiro says the autopsies raise as many questions as they answer.
And with all of your training, experience, education, reading all these books, you cannot tell us with a reasonable degree of medical certainty how many people were responsible for the deaths of these 2 people.
I said that one person could have done it with one single-edged knife, in my testimony.
Can you tell us with a reasonable degree of medical certainty how many people are responsible for these homicides?
No.
Then the case of California versus O.J. Simpson shifts again to the gloves.
People's 164A.
Prosecutors are trying to show the 2 gloves found in the case belong to O.J. Simpson. A glove buyer from Bloomingdale's in New York testifies that the gloves in this case are a rare style and that Nicole Brown Simpson bought 2 pair in 1990.
The people would ask that Mr. Simpson step forward.
Then, Christopher Darden puts the state's case on the line. He brings O.J. Simpson before the jury to try on the bloody gloves, the one found at Rockingham and the one found at Bundy. It is an effort to show that if the gloves fit, the verdict is clear.
Other hand, please.
But do they fit?
We proceed with the demonstration, Your Honor.
Darden summons the defendant to try on a new pair of extra-large leather gloves.
All right, Mr. Simpson, would you show your hands to the jury, please?
And this time, the gloves fit.
There are a series of photographs that are...
That's not all that fits, say prosecutors. They call an FBI authority on shoe prints, and he testifies that the person who left a trail of bloody shoe prints at the murder scene wore size 12 shoes, the same size worn by O.J. Simpson. The shoes worn by the killer have never been found, and so the witness places O.J. Simpson's Reeboks sole to sole to a pair of Bruno Magli shoes that he says are the same type of shoes that left the bloody prints.
For all practical purposes, identical in the size and shape.
But defense attorney F. Lee Bailey questions the state's conclusions.
What do you know besides the fact that you have some size 12 Reeboks that are apparently his that would make him a candidate?
Nearly 5 months after prosecutors began their case, they embark on a final important phase. Through hair and fiber evidence found at the murder scene and elsewhere, prosecutors will try to link O.J. Simpson further to the crimes.
I do.
Douglas Diedrich, an FBI hair and fiber expert, testifies that hairs taken from the glove found at O.J. Simpson's home are consistent with hair from both victims.
How many hairs did you actually find on the Rockingham glove that exhibited the same microscopic characteristics as the hairs of Nicole Brown?
I believe there were 4.
You did find cut, torn, and forcibly removed hairs on the Rockingham glove consistent with those of Ron Goldman, correct?
Well, they were cut and torn, and again, that's forcible removal. Those were found on the Rockingham glove.
Next, Clark tries linking O.J. Simpson directly to the crime scene.
First of all, how many overall head hairs did you find that exhibited the same microscopic characteristics in that cap as the defendant's hair?
Well, there were 12.
Prosecutors contend this finding is highly incriminating, but they're not done yet. The next day, Diedrich testifies that Simpson's Ford Bronco had a very rare carpet type, and fibers from it were found on the knit cap at the murder scene and on the glove found at Simpson's home. But defense attorney F. Lee Bailey contends this new evidence is highly speculative.
As compared to fingerprint identification, or foot impression identification, or the identification of projectiles fired by weapons, this is a much more subjective science, is it not?
The courts have never recognized hair examinations as a positive means of identification, and we don't either.
As with the DNA results, the jury must determine the validity and importance of this new scientific evidence.
There will be a complete picture that will be simply overwhelming and undeniable of the defendant's guilt.
Prosecutors had suggested they would end their case with important new testimony or on a highly emotional note. In the end, it was anything but that.
This was the last time that Judita Brown spoke to her daughter, Nicole Brown Simpson.
Judita Brown did not take the witness stand. Instead, Marsha Clark read her testimony to the jury. Judita Brown had spoken to Nicole on the telephone within an hour of her daughter's murder.
Is there anything further from the people?
At this time, subject to the receipt of the people's exhibits into evidence, the people rest.
Well, I think that we did pretty well. So I'll put it that way. We did pretty well on their case.
The mountain, truly, the giant mountain of evidence that we have produced in court over these many weeks points to only one person. And we know who that person is.
That person, the state says, is O.J. Simpson. But after 92 days of testimony, some 58 witnesses in all, and the blood drops, the shoe prints, the gloves, the hair, and the fiber evidence presented, have prosecutors proven to the jury that O.J. Simpson killed his ex-wife and her friend? Now, of course, at every turn, the defense has tried to raise doubts about Simpson's guilt. And they're not finished yet. The defense case is next. For Court TV in Los Angeles, I'm Greg Jarrett.
O.J. Simpson murdered Nicole Brown and Ronald Goldman.
Defense lawyers attack practically every aspect of the state's case against O.J. Simpson.
This case is about a rush to judgment.
They say police botched their investigation.
It fell below a minimum standard.
They say the state's scientific evidence is unreliable.
The LAPD lab is a cesspool of contamination.
And suggest a racist cop planted evidence as part of a conspiracy to frame Simpson. From Los Angeles, the O.J. Simpson trial, the defense case.
All right, back on the record in the Simpson matter.
Hello, I'm Greg Jarrett. After 106 days in court, O.J. Simpson's attorneys are ready to present their case. And as Judge Lance Ito reminds the jury, it's the state's job to prove guilt beyond a reasonable doubt. O.J. Simpson is not obligated to prove anything at all. His attorneys nevertheless set out to cast doubt on just about every aspect of the state's case. Did police rush to judgment in this case? Is the state's scientific evidence reliable? And did a racist cop plant evidence as part of a conspiracy to frame O.J. Simpson for a crime he did not commit? These are the central questions the defense will raise in their effort to create doubt about O.J. Simpson's guilt.
Your Honor, the first witness that the defense will call is Ms. Arnell Simpson.
The defense begins by reintroducing O.J. Simpson to the jurors as a family man crushed by the news of his ex-wife's death. The defendant's daughter, sister, and then his mother describe O.J. Simpson's mood when he first learned Nicole Brown was dead.
Upset, out of control, distraught, emotional.
What I would say is that he was out of it. You know, he was shocked, dazed.
Oh, he seemed very upset. Shocked.
The defense offers a far different picture than that provided by prosecution witness Ron Shipp, who said Simpson was mainly concerned about himself and DNA results when he first learned of Nicole's death. Earlier, Shipp testified that Simpson also made incriminating statements the night after Nicole's death.
He kind of jokingly just said, you know, to be honest, Shipp, that's what he called me, Shipp, said, I've had some dreams of killing her.
Simpson's family members cast doubt on Shipp's memory and credibility. The defendant's daughter and his sister Carmelita describe Shipp's activity that evening.
He was sitting at the bar.
Was he drinking over a period of time?
Yes, from the time I was there until the time he left.
Did Simpson really make incriminating statements to Shipp that night? He didn't have a chance, says Simpson's older sister, Shirley Baker.
You are absolutely certain at no time did your brother speak privately to Ron Shipp in the bedroom that night?
I'm absolutely certain, yes.
Next witness, please.
Ms. Carol Connors.
The defense ends its first day of testimony by reminding jurors that Simpson had moved beyond his relationship with Nicole Brown. Songwriter Carol Connors saw O.J. Simpson with Paula Barbieri at a fundraiser the night before the killings.
I happened to witness, or I happened to see, a very exquisite romantic moment
that took place between the two of them. And being a writer, I was able to compute it into my brain and to understand it and to wish that I had been lucky enough to be in a situation of what I had watched.
What do Connor's observations say about what Simpson may or may not have been doing at the time of the murders? Not much, suggests prosecutor Chris Darden.
How about the night of the 12th? Did you see the defendant around 10:20 on the night of the 12th?
No, I did not.
Did you speak to him at that time?
No, I did not.
You don't know where he was at that time?
No, I do not.
Your Honor, we would ask leave of court to call Miss Mary Collins to the stand.
Mary Collins, an interior decorator, met with Simpson and Paula Barbieri to discuss plans to redesign Simpson's bedroom.
She was looking at samples of choices I brought, and they were discussing with each other which they preferred, and they seemed to be agreeing pretty much on the same things.
Collins may have glimpsed O.J. Simpson's intimacy with his new girlfriend, but prosecutors show that she, too, has no idea what the defendant was doing at the time of the murders. The next witness, Jack McKay, played golf with O.J. Simpson at a Hertz-sponsored tournament just 4 days before the killings.
He was very cordial, friendly, very willing to shake hands, sign autographs, have pictures taken. Very much different, I would say, than other celebrities that I've had an occasion to play golf with.
Prosecutor Marcia Clark gives jurors reason to discount the witness's insight into Simpson's character.
June the 8th is the only time that you ever had any contact with Mr. Simpson, is that right?
That's right.
McKay is, for the time being, the last of the defense witnesses called to testify as to O.J. Simpson's demeanor before his ex-wife's death. Next, the defense begins its attack on the prosecution's timeline. Danny Mandel is the first of many witnesses called to say that all was quiet and calm outside Nicole Brown's condominium at the time prosecutors say Brown and Ronald Goldman were stabbed to death.
Was there anything unusual whatsoever at approximately 10:30 on June the 12th that you recall when you walked by the condominium of Nicole Brown Simpson?
No.
Mandel was on a blind date that night with Ellen Aronson. Aronson, too, says all was quiet outside Brown's condominium.
As you walked past 875 Bundy, did you at any time hear the plaintive wail of a dog?
No, I didn't.
This is a very important point. Prosecutors say the murders happened at about 10:20, when prosecution witness Pablo Fenves says he heard Brown's dog wailing plaintively.
It sounded like a very unhappy animal.
If the murders occurred at about 10:20, as prosecutors contend, O.J. Simpson would have had time to clean up, ditch the murder weapon, and get home by 11 o'clock, when limo driver Alan Park met him there. That's why the defense wants to show the murders took place later. They call more witnesses who say the dog started barking, and by implication the killing occurred at least 15 minutes later than prosecutors say. Denise Pilnack says she is a stickler with time.
All right. And to the best of your recollection, what time was that you heard this dog barking at that point? Your best recollection?
About 10:35.
You heard this Akita start to bark?
Oh, yeah, hysterically, panicking.
And you heard that at about 10:35?
10:35, right.
Robert Heidstra helps knock the state's timeline, but he causes real problems for the defense. For starters, he places a car like Simpson's at the crime scene.
And what color was the car?
A very light color, white or something.
It was light or white?
Yeah, white or something.
As defense attorney Johnny Cochran reminds the jury again and again, Heidstra says the car sped off down Bundy and away from O.J. Simpson's home. But the damage has been done, and prosecutors are quick to use Heidstra to their advantage.
Didn't you tell Mr. Field that the vehicle you saw was a Ford Bronco?
It could have been a Blazer or Ford Bronco, they resemble.
Heidstra also says he heard people arguing outside Brown's condominium.
All of a sudden I heard two voices.
All right, you heard two voices?
Yeah.
All right, and what did you hear these two voices say?
Well, the first one I heard was a clear male young adult voice that said, hey, hey, hey.
Did Heidstra hear O.J. Simpson fighting with Ronald Goldman right before he slashed his throat? Prosecutors suggest that's exactly what Heidstra heard.
The second voice that you heard sounded like the voice of a black man. Is that correct?
Sustained.
But this statement about whether somebody sounds black or white is racist, and I resent it.
This is the witness's statement, and if the statement is racist, then he is the racist, not me. Okay? And clearly, I mean, but that's what you're suggesting, and that's what, you know, has created a lot of problems for my family and myself. Statements that you make about me and race, Mr. Cochran.
Well, you should
and
stop
I would
doing
indicate to
these
the court.
things.
Wait. I'm going to take a recess right now because I'm so mad at both of you guys. I'm about to hold both of you in contempt.
Darden's question may have caused a stir, but he has made his point, and it doesn't help the defense. The defense changes tacks. They call a series of witnesses who say Simpson did not act like a man who committed a double murder on the night of June 12th. Wayne Stansfield was the pilot on Simpson's flight to Chicago. The defendant agreed to autograph the pilot's flight log. Peace to you, Simpson wrote under his name.
Did he appear to be relaxed?
Yes, he did.
Did he appear to respond to your questions in an alert fashion?
Yes, he did.
Did you see anything at all unusual about him that night?
No, sir.
Several passengers, including photographer Howard Bingham, who knew Simpson, saw him on the plane.
He had seemed like the old O.J. that I always see here and there.
He was very pleasant, smiling. I noticed his clothing was very well pressed.
The defense has a keen interest in Simpson's left hand. Raymond Kilduff, a Hertz employee, took Simpson to the airport the morning after Nicole's death.
Did you have an occasion to observe anything unusual about Mr. Simpson's hands?
Yes.
What did you observe?
That it was cut and bleeding.
Which hand did you observe that on? Do you recall?
Yes.
Which
The
hand
left.
was that?
Simpson has said he cut his hand in Chicago after he heard what happened to Nicole, and a series of defense witnesses support his story.
I didn't see anything unusual, no Band-Aids, no large abrasions or anything to that effect.
You see any cuts at all?
I didn't see any.
See any blood on his hands?
No blood.
I saw his left and right hand.
All right. And did you notice anything unusual about either his left or right hand?
I did not notice anything unusual.
Did you see any cuts on either his left or right hand?
I don't think so, no.
Did you see any blood on either his left or right hand?
I did not.
These witnesses help rebut the state's contention that Simpson cut his hand in the course of the double murder he committed before he left for Chicago. Moving to a new phase of the case, the defense presents evidence showing O.J. Simpson was too weak and frail to have stabbed two people to death.
There are some very lucky people that looks can be deceiving, and certainly in his case, although he looked like Tarzan, you know, he was walking more like Tarzan's grandfather.
Dr. Robert Huizinga examined Simpson 3 days after the murders. He says the defendant suffered from osteo and rheumatoid arthritis and post-NFL syndrome, a permanent disability caused by repeated banging of the head and body against the football turf.
What about his mobility on the 15th? Do you have an opinion as to his ability for lateral movement?
I think his ability for lateral movement would definitely be diminished based on his left knee and right ankle problems.
The doctor says Simpson's poor health severely hampered his capacity for sport.
He would be able to play a sport where he was essentially didn't have to move much or certainly very quickly. Something that he could stand, he would be able to shoot free throws, for instance. He would be able to play golf. He would be able to arm wrestle if it wasn't the side involving possibly the injured wrist. He would be able to play billiards.
Prosecutor Brian Kelberg shows that despite O.J. Simpson's alleged arthritis and other ailments, he was not entirely disabled on June 12th.
Doctor, was there any finding made by you covered in whatever item number 1 is, which dealt with any physical limitation of Mr. Simpson's, which in your opinion would have prevented him from murdering 2 human beings using a single-edged knife on June 12th of 1994.
Objection.
Overruled.
You may answer the question, Doctor.
No, there was not.
Kellberg spices his lengthy cross-examination with demonstrations designed to show the jury just how O.J. Simpson, despite his physical limitations, could slit his ex-wife's throat.
He then, with his right arm...
But the most dramatic moment came when prosecutors played for Dr. Huizinga and the jurors a videotape made just 2 weeks before the murders.
It's like the Watusi, isn't it? It's like dancing. See what I mean? Get loose, and I feel like going. You know, getting loose juice, as they call it. The very thought of you.
See, I knew it was going to happen.
And I forget to do.
Man.
Oh,
Tell you, this
do I look
area
like
right
Arnold
here.
Schwarzenegger here, guys? Tell me
One
about
of the most underdeveloped parts of the body. Ready.
Does the man on this videotape look like Arnold Schwarzenegger or Tarzan's grandfather? Is he really as infirm as the defense claims? Unfortunately for the defense, Simpson doesn't just flex and stretch on the tape. He wisecracks, too.
I'm telling you, just got to get your space in if you're working out with the wife, if you know what I mean. You can always blame it on working out.
Though Simpson's attorneys dismiss the wife-beating quip as a harmless gag, it doesn't exactly help their case.
I started taking regularly Juice Plus and started feeling, I don't know if it was mind over matter, it was a mental thing, but almost immediately I started feeling better. All of a sudden I was getting another 10 yards on my drive and then before I knew it, I just started skipping the Naproxen and skipping the Indocin and skipping the pain pills, the Advil. I mean, I was one of these guys with 6, 7 Advils a day, you know, and until the day where I don't have to take anything. And
even Dr. Huizinga had a tough time explaining away the defendant's clean bill of health 3 months before the murders. The occasion was a pep talk for a drink called Juice Plus.
I cannot get inside Mr. Simpson's head. I do know that he had a lack of understanding of his rheumatoid arthritis. He constantly denied the fact that he had rheumatoid arthritis. He did not want to see himself as an arthritic patient.
Huizinga spent 3 days on the witness stand, more time than any defense witness so far. After he's excused, the defense picks up the pace once again as they move on to yet a new phase of the defense. Hairs found in a ski cap at the crime scene showed traces of dandruff. Some of the hairs were dyed.
Ms. Moore, what is your occupation, ma'am?
I am a barber.
The next defense witness, Juanita Moore, cut O.J. Simpson's hair for more than 16 years.
You know how they say only your hairdresser will know for sure?
Yeah.
All right.
Yes.
So you never at any time tinted or dyed his hair, is that correct?
No, I didn't.
All right. Now, in that connection, during the time, the 16 years that you cut Mr. Simpson's hair, did he have dandruff in his hair?
Periodically, he would have dandruff, yes.
Police officer Donald Thompson arrested Simpson when he returned home from Chicago.
Prior to your seeing Mr. Simpson there at about 12 noon on June 13th, had you had a conversation with a detective by the name of Van Adder?
Yes, I did.
And did Detective Van Adder give you some instructions with regard to what to do when you saw Mr. Simpson arrive at the location?
Yes, he did.
What did he tell you to do? Well, thank you. You may answer.
He told me to place the defendant in handcuffs as soon as he arrived.
Well, now, didn't he say specifically told you to hook him up or cuff him, referring to Mr. Simpson when he arrived?
Yes.
All right.
This helps reinforce the defense theory that police rushed to judgment. The next witness, tow truck driver John Mraz, looked inside O.J. Simpson's Bronco before he towed it to a police department shed.
Did you see any blood on the inside of that vehicle at that time?
I didn't see any blood at all.
Mraz's testimony supports the defense theory that police planted evidence against the defendant. Prosecutor Marcia Clark, however, offers a photograph of the Bronco's interior, and Mraz is forced to admit that blood is visible inside the car.
You're not telling this jury that there was no blood inside the Bronco, are you? You're just telling them you didn't see it.
Telling them I didn't see any blood.
And you don't recall seeing the blood that you now see in this photograph?
I didn't see that in there.
The defense returns to O.J. Simpson's physical limitations and to the exercise video he made. Fitness trainer Richard Walsh produced and co-hosted the tape.
I thought he was too physically limited to be the co-host with me.
And why did you think that?
Because I knew the type of tape that I was making needed, you know, not somebody real physically fit, but it needed someone who had the ability to at least be mobile laterally, forward and back, using upper body muscle groups and so forth.
Did you notice anything about Mr. Simpson's ability to move laterally or from side to side?
It was pretty limited.
Walsh says that Simpson had a tough time performing various moves.
Now, this is something I would have a little problem with because my knee hitting the ground, I can't quite do it.
All of a sudden I looked at OJ and he was kind of coming at me like he was carrying a football. Kind of like this, but just kind of moving slow. And as he got near me, I just kind of took my elbow like a football player would and kind of hit him, but very lightly.
And when you struck his body at that point?
Like his elbow or shoulder or arm or something like that.
Did you see his reaction when that happened?
He started literally flying. I mean, not flying in the air, but he started jumping around and hobbling, and he started screaming, my knee, my knee.
The state shows that despite his handicaps, Simpson held up throughout the 12-hour exercise taping session.
We got to push-ups. I got back on my feet, I started walking, and I looked at him, and I said something to the effect that, again, I don't know the exact words, but something to the effect that, geez, too bad you're not tough enough to make it through this. And I just kept walking, or something along that lines to try to motivate him or kind of tease him a little bit that, you know, I'm plenty strong enough to keep going, it's too bad you're not. And
okay, and so what did the defendant say to you after you teased him a little bit?
Kind of looked at me and something, in fact, he said something like, let's go, let's do it.
Next, the defense fixes its attention on the bloody socks that police say they found on O.J. Simpson's bedroom floor. Willie Ford, a videographer for the LAPD, made a videotape inside Simpson's home the day after the murders.
See that carpet there, that rug, right in front of the bed?
Yes.
Saw that rug that particular day, did you not?
Yes.
And in fact, you walked past that rug when you went into the other room, into the bathroom area, didn't you?
Yes.
Any socks on that rug that day, Mr. Ford?
No.
You didn't videotape any, there were none there, isn't that correct?
That's correct.
It was 4:13 p.m. about that time on June 13th, 1994 that you walked through there, right?
Yes.
If there had been socks there, you would have taken photographs of them or video.
Yes.
Correct?
Did police plant the bloody socks after Ford made his videotape? That's what the defense wants jurors to believe. After Ford leaves the stand, the defense calls Simpson's housekeeper. Josephine Gigi Guarin says her boss was so neat and orderly, he even color-coded his closet. She says Simpson always put his clothes away.
Any time during the time you worked for Mr. Simpson, have you ever seen him leave any socks on the rug or on that carpet in his room at any time, out like that?
No.
The focus now turns to the question of how blood got on the socks allegedly found in O.J. Simpson's bedroom and on the gate behind Nicole Brown's condominium. Forensic toxicologist Frederick Reeders says that samples taken from the socks and the gate contained EDTA, a preservative used in police labs.
Do you have an opinion on whether the EDTA found on the sock and the back gate, in the quantities in which they were found, if that could have come from a purple top tube?
Yes, of course it could.
This is the first scientific evidence offered to support the defense theory that police planted blood on the socks in order to frame O.J. Simpson.
Is it your opinion that the bloodstains on the sock and the gate had to have come from the preserved blood to the exclusion of all other sources?
I didn't say that. I said that it's sort of like you hear hoofbeats, it's probably horses and not zebras, is that the most likely source for EDTA in a blood sample, when you have a control that is negative, is that it was EDTA blood to begin with. That's what I said.
Unlike many previous defense witnesses, Reeders held his own under Clark's tough cross-examination. An explosive development. The action in the Simpson case suddenly moves to North Carolina, where professor and aspiring screenwriter Laura Hart McKinney lives. McKinney says that Mark Fuhrman frequently used racial epithets while the two worked together on a screenplay.
That's what I'm saying, sir.
McKinney's conversations with Fuhrman are tape recorded, and the defense wants jurors to hear those tapes.
We're not here trying to say that we're going to prove that Mark Fuhrman framed O.J. Simpson, or we got to prove that he did so-and-so. What we're going to prove is that he's a liar.
That, Cochran argues, is central to the defense. Earlier, when Mark Fuhrman was on the witness stand, he said he had not used the so-called N-word in 10 years.
This material is collateral.
The North Carolina court, however, decides those tapes are not material to the question of O.J. Simpson's guilt and says the defense cannot subpoena McKinney or her tapes.
And we're obviously going to appeal because it's just flat out wrong.
This is not the last time we'll hear of Mark Fuhrman, or the tapes on which the detective talks about arresting people merely because they are black, about framing innocent people, and beating and shooting citizens. The defense continues to raise the specter of a police conspiracy to frame O.J. Simpson. The focus remains on Simpson's blood and the question of how it found its way into all sorts of incriminating places. A blood spatter expert, Herbert McDonald, says that blood on Simpson's sock doesn't seem to have been spattered there, as the state claims, but was deliberately smeared onto the sock. This, of course, supports the defense idea that police planted blood in order to frame Simpson.
In your opinion, Professor McDonald, is the ankle stain that you saw a spatter stain?
Not based upon just what you've said or my examination. The examination.
No.
Not based upon the examination that I made of the socks at that time. I did not find any distribution of blood that I could consider a spatter.
But on cross-examination, McDonald admits the fact that the blood wasn't spattered doesn't necessarily mean that police smeared blood on the socks, as the defense contends.
If Nicole Brown Simpson reached out a bloody hand to touch the ankle of the murderer wearing those socks, could that cause a compression or a swipe transfer?
Objection, no foundation.
Certainly it could. Anything that has blood on it can either be projected and touch the area that's stained, or this area that's stained could have come in contact with it. It's simple transfer.
The defense moves into a new phase. The aim now is to show that police work on this case was bungled and incompetent. John Gertis studied blood tests performed by the LAPD.
Have you an opinion to a reasonable degree of scientific certainty about contamination at the LAPD DNA laboratory?
Yes.
What is it?
I found that the LAPD laboratory has a substantial contamination problem that is persistent and substantial.
Is the LAPD, in terms of levels of contamination, worse than any other forensic laboratory you've ever seen?
Definitely. By far.
Gertis makes a key point for the defense. The state's DNA evidence is not reliable. Nicole Brown Simpson, Ronald Goldman, and O.J. Simpson's blood could easily have been cross-contaminated in what Gertis called the cesspool of contamination that is the LAPD lab.
You have no specific forensic training, isn't that correct?
That's correct.
You've never taken a class in forensic science?
That's correct.
You've never taught a class in forensic science?
That's correct.
You have no training whatsoever in police evidence gathering techniques, correct?
No formal training.
After assailing the witness's qualifications, prosecutor Woody Clark suggests Gertis is a hired gun who always works for defense attorneys trying to shoot down DNA evidence.
Well, how many times have you been retained by a prosecutor?
Once.
Did that involve a case where a prosecutor was trying to keep DNA evidence out?
Yes.
Was that the only time you've been retained by a prosecutor?
Yes.
So is it correct then, every time you've been retained to look at evidence in an individual case, it has been to try to keep that evidence out?
I think that's vague and overbroad.
Sustained.
Assuming the prosecution convinced jurors that Gertis is a hired gun without much DNA experience, will jurors convict O.J. Simpson when there's a possibility the DNA evidence against him was contaminated? The next big development once again takes place in North Carolina, where a court of appeals paves the way for the defense to subpoena the now famous Fuhrman tapes.
I think that the ruling in North Carolina today by the North Carolina Court of Appeals is probably the key, most important ruling in the case thus far, from the standpoint of Mr. Simpson.
The defense has built its case around the idea that there was a racially motivated conspiracy to frame O.J. Simpson. The audio tapes will certainly serve defense purposes. The next witness, former New York City Chief Medical Examiner Michael Bodden, says neither Nicole Brown Simpson nor Ronald Goldman died the way prosecutors say they did.
My opinion is that Ms. Simpson struggled for some period of time with the assailant, during which time she received various stab wounds, including the stabs, the injuries to the hands.
This is important. Earlier, the L.A. coroner testifying for the state said Nicole and Ronald Goldman's attacker took his victims by surprise and killed them quickly. Each killing could have taken less than a minute, he said, giving O.J. Simpson enough time to ditch the murder weapon and his bloody clothes and meet up with limo driver Alan Park by 11 o'clock. If Bodden is correct about the protracted struggle that took place before the killings, the state's theory falls apart. Dr. Bodden also attacks the state's theory that Nicole Brown and Ron Goldman were attacked by a single killer.
In this case, can you tell within a reasonable degree of medical certainty how many killers were involved in this case?
No.
In your opinion, can anybody tell how many killers were involved in this case?
The medical examiner can't. The medical examiner, from the nature of the injuries, of the wounds, and the crime scene, cannot tell how many assailants there were.
In a bigger development for the defense, Judge Ito takes possession of the Fuhrman tapes and, after some haggling about which side could listen to them first, hands the tapes over to Johnny Cochran. Anticipation and dread from the prosecutors as to what might be on those tapes eclipsed the proceedings, which bogged down once again in murky and highly technical scientific inquiries. Frederick Reeders, a forensic toxicologist, returns to court. He told jurors earlier that he found EDTA, a chemical police used to preserve evidence, in blood lifted from the back gate at the murder scene and from the defendant's sock.
All right, Dr. Reeders, in this particular case, you did not do any testing on any of the evidence. Is that correct?
On what?
In this case, in the Simpson case, did you do any testing on any of the evidence?
No, I didn't.
You just interpreted the tests that were done by Agent Martz, correct?
That's correct.
And those tests were performed on equipment that you have never operated, correct?
Yes.
Because of a scheduling snafu, Prosecutor Marcia Clark did not get a chance to finish cross-examining Reeders until now. Clark continues her vigorous cross-examination by reminding jurors how little direct knowledge of the evidence the witness has. A long digression into the matter of whether or not Dr. Reeders misidentified the cause of death in yet another case, 7 years old, leaves spectators glassy-eyed and seems to try Judge Lance Ito's patience.
Next question. Let's wind this up. Let's try the Simpson case sometime today. All right.
And he rejected them.
Wait. This is the end of this inquiry. It's completely irrelevant at this point. Move on to something else. I would love my wife dearly. And I am wounded by criticism of her.
The Simpson case takes a most unusual turn on August 15th, when defense attorneys find that the Fuhrman tapes contain derogatory references to blacks, Jews, women, and Judge Ito's wife, LAPD Captain Margaret York. Outside the presence of the jury, prosecutors pressed Judge Lance Ito to withdraw from decisions on two key issues. Should jurors hear the Fuhrman tapes, and should Captain York be called to testify? Judge Ito agrees his connection to York may create an appearance of impropriety.
I therefore recuse myself from the issue of the tapes themselves, and specifically whether or not Captain York is a material and relevant witness.
Marcia Clark intimates this may not be good enough.
The only road to take is to not to waive any matters in this court and to proceed with a complete recusal from this point forward.
If Judge Ito withdraws from the case entirely, as Clark suggests he should, the proceedings could very well end in a mistrial. But Clark backs down the following day.
Although our review of the case law indicated that we are entitled under the law to seek the course of full recusal, we have determined that it is not the only course. And although the law does not expressly provide for a partial waiver of conflict, in consideration of all of the factors, Your Honor, we have decided that it would not be the appropriate course in this case.
Disaster averted, the defense moves to its final phase, one that centers on questions about Detective Mark Fuhrman and the Fuhrman tapes.
We have checked these tapes out, and there are at least 30 times when the so-called N-word is used.
Remember, the defense wants to play the tapes for jurors to show that Detective Fuhrman lied under oath when F. Lee Bailey questioned him earlier in the trial.
And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Fuhrman.
That's what I'm saying, sir.
If Fuhrman lied about this, says the defense, there is reason to believe he lied about other things, about finding a bloody glove on O.J. Simpson's property, for example. That is yet another reason the defense wants jurors to hear those tapes. Members of the victim's family, echoing prosecutors' sentiments, accuse the defense of ulterior motives.
They are trying to divert the attention away from the facts in this case, and the fact is their client is accused of murdering my brother and Nicole Brown, and the evidence against him is overwhelming.
We all know what they want is to inflame the emotions of the jury and to inflame anyone's minds, the public's minds, with issues that don't relate to this trial. Ron and Nicole were butchered by their client. Do any of you believe otherwise?
All the wrangling about the tapes has been conducted outside the jury's presence.
And at some point in time, we have to recognize the fact that we have a jury that is way overdue as far as the time that they were told that they would have committed. I'm very concerned about the durability of this jury as they sit.
Finally, testimony resumes. Fingerprint expert Gilbert Aguilar reviewed the prints left at the Bundy crime scene.
Now, when you got involved in the case in July of 1994, did you have occasion to look at the 17 prints lifted from Bundy and compare those prints yourself with those of Mr. O.J. Simpson?
Yes.
And what did you find, if anything, in that regard?
That none of the latent prints I recovered from the crime scene were identified to Mr. Simpson.
But prosecutor Chris Darden takes the sting out of Aguilar's testimony.
You wouldn't expect a person wearing a pair of leather gloves to leave fingerprints at a location.
Oh, well.
No.
The next witness, crime scene expert John Larry Raggle, says police botched their investigation of the Bundy murder scene.
Do you have an opinion as to whether their processing of the crime scenes in this case fell above or below a minimum standard of practice?
Still no foundation, not relevant, calls for opinion and speculation.
Oh, well.
You can answer.
Yes, I have an opinion.
And what is that opinion?
That it fell below a minimum standard.
Slowly, Raggle recounts the many ways in which police botched the investigation. But then prosecutor Hank Goldberg subjects him to a quick, dismissive cross-examination.
Now, since 1989, how many homicides have you been the primary criminalist who was investigating the crime scene?
None.
And how many crime scenes, homicide crime scenes since 1989, were you a secondary criminalist or assistant criminalist investigating that crime scene?
None.
How many rape crime scene investigations have you participated in as a criminalist since 1989?
None.
Any major crimes or significant crimes since then?
No, none.
And, sir, is it a correct statement of the record in your testimony in this case that it's been 19 years since you've actually been in the field as a criminalist and processed a crime scene?
Yes.
Thank you. I have nothing further.
The next witness, Christian Reichart, a friend of O.J. and Nicole Brown Simpson, describes the telephone call he says he received from O.J. Simpson just 90 minutes before the killings.
Mr. Simpson called, and you, of course, recognized his voice, did you not?
Absolutely.
And with regard to the tone of his voice, I want you to describe how Mr. Simpson's voice appeared during this conversation at 9 o'clock p.m. on Sunday evening, June 12th, 1994.
Oh,
You can answer the question.
okay.
You may answer.
He seemed a little bit more relaxed than in the recent months. He seemed very jovial.
All right. And you recall this specifically?
Yeah.
Did he seem downcast or sad at all during this conversation?
Not at all.
On cross-examination, prosecutor Chris Darden suggests Reichart's impression isn't worth much.
And so you received this call and it seemed jovial and relaxed, more relaxed, right?
That's correct.
Had you spoken to him the day before at all?
No, I haven't.
How about the day before that?
No, I haven't.
The day before that?
No, I haven't.
Had you spoken to him at all during the 7 days prior to Nicole Brown's murder?
No, I haven't.
Okay.
Detective Kenneth Barras inspected O.J. Simpson's Chicago hotel room after the defendant left for L.A.
In the bathroom area, can you describe for the jury what, if anything, you saw in the sink of the bathroom area there of Suite 915?
In the basin of the sink was a broken drinking glass.
And when the towel was lifted up, did you have occasion to see a washcloth or a face cloth?
Yes, I did.
Describe for the jury what you saw with regard to this washcloth or face cloth.
That washcloth had a reddish stain on it, which I suspected to be blood.
This, of course, supports the defense contention that O.J. Simpson cut his finger on a glass in Chicago after he learned of Nicole's death. But prosecutor Chris Darden cast doubt on this version of events, suggesting that though Simpson may have broken a glass in Chicago, there isn't any evidence he cut himself.
Could you point out the blood on the glass?
I observed no blood on the glass.
Your Honor, the defense calls Dr. Henry Lee.
Matters take a more exciting turn when Simpson's top forensic expert takes the witness stand. Dr. Henry Lee suggests the presence of a second assailant.
If this parallel line imprint comes from a shoe, could it be the Bruno Magli shoe? No. It would be some other shoe. If this is a shoe, this is a different type of design than Bruno Magli. Dr. Lee, in your experience at crime scenes, have you ever seen a single assailant wear two pairs of shoes?
Oh.
No?
Dr. Lee, who treats jurors to blood spatter demonstrations, lends support to the defense theory that police tampered with evidence. He looked at 7 cotton swatches of Simpson's blood. 4 of them left stains when they were placed on paper the following morning.
You told us that one would expect that these swatches, having been put in a test tube at 6:30 p.m. on June 13th and removed at 7:30 a.m. on June 14th, to be dry. Yes. Given that fact,
Given that opinion,
what is your opinion about the existence of these transfer stains?
Overall.
Only opinion I can giving under this circumstance, something wrong.
Does that mean that if you look at something and you can't explain it as a forensic scientist, that there's something wrong?
Yes, there's something wrong.
Prosecutor Hank Goldberg makes little headway with Dr. Lee on cross-examination, though he does succeed in casting doubt on the eminent doctor's suggestion that the shoe print at the crime scene belonged to a second killer.
Sir, hypothetically, if these police officers that we saw in the video walked through the area after the crime scene was broken down, if Nicole Brown's family walked through the crime scene after it was broken down on June the 13th, if an individual by the name of Ron Hardy walked through and hosed portions of the crime scene on June the 14th, and a number of other people walked down the walkway prior to the time that you got there. Yes, sir.
Proper foundation.
Can you eliminate the possibility that those people deposited prints at the scene?
I cannot eliminate.
Thank you very much, Doctor.
Thank you.
When jurors come into court on August 25th, Judge Lance Ito informs them they've set a record.
As of yesterday, you have surpassed the amount of time that the Manson jury, if you recollect from 20 years ago, was in sequestration, so some kind of a dubious record, I'm sure.
Outside the jurors' presence, Judge Ito gives the attorneys a grim appraisal of their condition.
My impression is that they are tired, and
We understand
they are, I wouldn't say close to the brink, but they're certainly within eyesight.
The jury will, however, be precluded from the drama inside the courtroom over the next several days.
You're trying to find a bruise on a nigger? Pretty tough, huh?
Judge Ito allows defense attorneys to play the hate-filled Fuhrman tapes. He has yet to decide how much, if any, of the tapes the jurors will hear.
Basically working practice movements. Niggers. So what are you saying? I just practice my kicks. You know why we stopped the show?
Tell me.
We stopped the show because a bunch of niggers have a bunch of these organizations in the South End, and because all niggers are choked out and killed 12 in 10 years. Really extraordinary, isn't it? First thing, anything out of a nigger's mouth for the first 5 or 6 sentences is a fucking lie. That's just right out.
In addition to Fuhrman's racist remarks, the world hears him brag about abusing power and citizens.
We basically tortured them. There's 4 policemen, 4 guys. We broke numerous bones in each one of them. Their faces were just mush.
The defense plays additional excerpts, which they say reveal the witness's attitude.
I'm the key witness in the biggest case of the century, and if I go down, they lose the case.
I think it's important to put ourselves in the position of the jury looking at the testimony of Mark Fuhrman. I know that's hard after we've read all of these transcripts and listened to all of these tapes and come to the sickening realization of who Mark Fuhrman really is. Los Angeles' worst nightmare, probably the greatest liar since Ananias. But the jury has only seen a very polished and professional performance that was carefully orchestrated, in which Detective Fuhrman sounded more like a choir boy.
After the tapes are played, the attorneys argue about how much, if any, of the tapes the jurors should hear.
I am deeply offended, and I'm shocked, and I'm disgusted with what I've heard. But I cannot afford the luxury of being Marcia Clark, the citizen. I am Marcia Clark, the prosecutor, and I stand before you today, Your Honor, not in defense of Mark Fuhrman, but in defense of a case of such overwhelming magnitude in terms of the strength of the proof of the defendant's guilt, that it would be a travesty to allow such a case to be derailed with a very serious and important, but very inflammatory social issue.
This is not something that I can rule upon from the seat of my pants. I need to sit down and look at each one of these individual situations and make the appropriate ruling.
Outside the courtroom, arguments rage.
I don't understand why the hell we had to listen to 2 hours of this hate. It's disgusting, every word that was said. But there's no reason that it had to go out on public airways all day long, and more to come. It's exactly what I said it would turn into a week ago. This is now the Fuhrman trial. It's not the trial of O.J. Simpson, who is accused of murdering my son and Nicole.
In a 10-page ruling, Judge Lance Ito decides the jurors will hear just 2 relatively innocuous portions of the Fuhrman tapes. In a big blow to the defense, Ito also bars the defense team from playing any of the 18 taped instances in which the detective bragged about fabricating evidence, framing people, and other police misconduct.
This statement is from Mr. Garcetti. While we decry racism, these tapes are for another forum, another time, and not this murder trial. The court's ruling today will help keep the focus where it should be, which is on relevant evidence that allows the jury to determine whether Mr. Simpson is responsible for the murders of Nicole Brown and Ronald Goldman. Now, let's get on with this trial and get it to the jury.
After a full week without a word of testimony, the jurors return to court. The defense offers a series of witnesses who tell graphic tales of Mark Fuhrman and his racist exploits.
He said that if, when he sees a black man with a white woman driving in a car, he pulls them over.
And what did you say?
I was taken aback a little bit, and so I kind of paused and I looked at the Marines and I just said, well, what if they didn't do anything wrong?
And what did he say?
He said he'd find something. And he said if I had my way, I'd gather, all the niggers would be gathered together and burned.
Officer Fuhrman turned around, looked at me, and told me, I told you we'd get you nigger.
He said, the only good nigger is a dead nigger.
Laura Hart McKinney made the Fuhrman tapes. She planned to use them to help flesh out her screenplay on big city cops.
During the time that you talked with Mr. Fuhrman, during this 10-year period of time, did he ever use the racial epithet, which I'll call the N-word, during the course of your conversations with him?
Yes, he did.
And in the course of your preparation of your testimony here today, can you tell the jury how many times you've counted that he used that word?
Approximately 42.
42 times?
Finally, Johnny Cochran plays the excerpts Judge Ito has allowed the jurors to hear.
Can you compare that with the other 42 times or so that he used this in the course of your interviews? If there any difference between how I used the term there and the other 42 times or so? Objection. You may answer.
Yes, there's a significant difference here. This particular example is the least offensive and inflammatory in comparison to the others.
The next, perhaps most dramatic moment in the defense case takes place outside the presence of the jurors.
Detective Fuhrman, was the testimony that you gave at the preliminary hearing in this case completely truthful?
I wish to assert my Fifth Amendment privilege.
Have you ever falsified a police report?
I wish to assert my Fifth Amendment privilege.
Is it your intention to assert your Fifth Amendment privilege with respect to all questions that I ask you?
Yes.
I only have one other question, Your Honor.
What was that, Mr. Fuhrman?
Detective Fuhrman, did you plant or manufacture any evidence in this case?
I assert my Fifth Amendment privilege.
Mindful of how damning Fuhrman's invocation of the Fifth Amendment looks, the defense wants to recall the detective and repeat the spectacle in front of the jurors.
It is not appropriate to call a witness before a jury that counsel know will invoke the privilege. The court will therefore deny the request to recall Detective Fuhrman at this time in front of the jury. Therefore, the court will instruct the jury as follows. Detective Mark Fuhrman is not available for further testimony as a witness in this case. His unavailability for further testimony both on cross-examination is a factor which you may consider in evaluating his credibility as a witness.
It sounds like a victory for the prosecution, but prosecutors are enraged. Marcia Clark says she'll file an emergency appeal.
I doubt that a court of appeal, frankly, is going to intervene on an interim jury instruction.
I would be surprised if they did.
The appeals court doesn't merely surprise Judge Ito, it delivers a stern rebuke. The appeals court says Ito cannot tell jurors they may draw adverse inferences from Fuhrman's absence. Nor, says the higher court, can Ito comment on the reason Mark Fuhrman is not available to testify.
Certainly it is a victory, but it's a victory for justice and the truth.
Hoping to rest their case with the dramatic flourish that Fuhrman would have provided had he been recalled before the jury, the defense refuses to rest.
I am not, on behalf of my client, prepared to rest.
Johnny Cochran fulminates about the high court's ruling.
We don't have to accept that. You may want to accept it. We don't accept it. We want to do something about it.
The defense appeals to the California Supreme Court. Concerned about the jury's eroding stamina, Judge Ito makes an unusual procedural decision.
And I am not going to require the defense at this time to rest. What I will do, though, is exercise my discretion under the penal code and direct that the prosecution, having indicated their ability to go forward with their rebuttal case, direct that they begin presenting their rebuttal witnesses at this time.
And so the state will begin its rebuttal case before the defense has finished presenting its case in chief. After a series of prosecution rebuttal witnesses, the defense calls its final witnesses. Philip Van Adder, the lead detective on the case, says he went to the Rockingham estate in order to tell O.J. Simpson that Nicole was dead and to make arrangements for the Simpson children who'd been taken to a police station. But the defense has information that Simpson was a suspect when Van Adder first went to his Rockingham home.
Did you tell Larry Fiato that you did not, that you went to Rockingham because O.J. was a suspect? The husband is always a suspect on the 18th floor of the balcony while smoking a cigarette in February of this year.
Again, if something is taken out of context, I don't have a specific recollection of making that statement. I don't believe I did make that statement. The truth of the matter is, Mr. Simpson was not a suspect. I went there to make a death notification and a disposition of 2 minor children.
What difference does it make if Simpson was a suspect? In most circumstances, police need a search warrant to enter a suspect's home. Police here did not have a warrant. Arguably, evidence seized at Simpson's home, including the bloody glove, could be suppressed as a result. But Craig and Larry Fiato, 2 former mob figures who've worked as FBI informants, say Van Adder told them Simpson was a suspect when police went to his home after the murders. FBI Special Agent Michael Wax was the Fiato's handler. Wax says he was present during the Fiato's alleged conversation with Detective Van Adder.
When you walked out there, you heard Detective Van Adder make a statement to Larry Fiato, isn't that correct? Can I answer that yes or no?
Yes.
And what statement did you hear Detective Van Adder say to Larry Fiato?
Well, I can't give you an exact quote. It was more of a comment, something to the effect of not going up to the house to save victims, and that he was a suspect.
Prosecutor Brian Kelberg tries to undo the damage done by the defense team's final witness.
In fact, the tone you heard in Mr. Van Adder's voice as he was saying the comment you heard him say was one of sarcasm, wasn't it?
In my opinion, it was totally sarcastic, yes.
One final showdown. When the defendant in a criminal case chooses not to testify, the judge routinely asks the defendant to state on the record that he is choosing not to take the witness stand. Outside of the jury's presence, Johnny Cochran tells Judge Ito that Simpson would like to say more than the standard, "Yes, I understand I have a right to testify, but I have decided not to do so."
Mr. Simpson would like to make a brief statement.
It's inappropriate. It's done very deliberately by the defense for a clear purpose. Please don't do this, Your Honor. I beg you. I beg you.
Clark says that the jurors won't hear this statement. They'll find out about it during conjugal visits or through other means. That, she says, is just what the defense wants. But one last time, Judge Ito rules for the defense.
Good morning, Your Honor. As much as I would like to address some of the misrepresentations made about myself and Nicole concerning our life together, I'm mindful of the mood and the stamina of this jury. I have confidence, a lot more it seems than Ms. Clark has, of their integrity, and that they will find, as the record stands now, that I did not, could not, and would not have committed this crime I have 4 kids, 2 kids I haven't seen in a year. They ask me every week, Dad, how much longer? How much this trial over? Thank you.
All right. Mr. Simpson, you do understand your right to testify as a witness?
Yes, I do.
All right. And you choose to rest your case at this. All right. Thank you very much, sir.
The jury is brought back into the courtroom, and then, finally.
I'm very pleased to say that we have no further testimony to present at this time, and as difficult as it is, the defense does rest at this point. Thank you.
The defense rests without calling a number of promised witnesses, including Rosa Lopez, Mary Ann Gerchis, and Al Callings, nor did jurors hear from O.J. Simpson himself. The defense, as we know, did not need these witnesses. By attacking the state's evidence, as well as police investigators, the defense created enough doubt about O.J. Simpson's guilt to avoid conviction. Next, defense attorneys and the prosecutors sum up for the jury. For Court TV, I'm Greg Jarrett.
Not guilty.
The jury speaks.
He's a murderer.
But not before the lawyers have their final say.
The proof is so devastating.
Somebody played with this evidence.
The defense case is smoke and mirrors. If it doesn't fit, you must acquit.
It would be a tragedy. We found the defendant not guilty.
Maybe you're the right people at the right time at the right place to say no more.
From Los Angeles, the O.J. Simpson trial, closing arguments, and the verdict.
We, the jury, in the above entitled action, find the defendant, Orenthal James Simpson, not guilty of the crime of murder in violation of Penal Code Section 187A, a felony upon Nicole Brown Simpson, a human being.
The stunning verdict that set O.J. Simpson free is forever etched into our minds. So too is the aftermath. Inside the courtroom, tears of anger, disbelief, and tears of utter joy. Outside the courtroom, outrage and elation. Hello, I'm Greg Jarrett. Whatever one thinks of the shockingly swift acquittal of O.J. Simpson, it has ignited a national debate about our system of justice. Should a jury have to endure such a long sequestration? Should they be sequestered at all? Must a verdict in a criminal trial be unanimous? Or can a majority of jurors reach a fair verdict? Well, the Simpson verdict has also exposed a hard truth about race relations in America, that we cannot assume a common understanding of justice. In the next hour, we'll look back at the final weeks of California versus O.J. Simpson, the case that captivated the world. It has been 7 months since the O.J. Simpson trial began. Before closing arguments get underway, prosecutors and defense attorneys have a chance to rebut points raised by the other side.
All right, Ms. Clark, are you prepared to present a new witness on your rebuttal case?
Yes, I am.
Prosecutor Marsha Clark embarks on her rebuttal before the defense officially rests its case. She sets out to answer a question the state failed to answer earlier. Do the bloody gloves in this case fit O.J. Simpson?
Ms. Clark, you may call your next witness.
Now Clark calls a parade of witnesses who photographed O.J. Simpson, the sportscaster, wearing leather gloves, which Clark points out seemed snug on him even then.
Does it appear short to you?
From the gloves I've worn, I mean, I've never owned a pair of these gloves, so I couldn't say, but from gloves that I've owned, I mean, usually they cover your palm.
Then your answer is yes.
Yes. That they appear short, yes.
All right, Richard Rubin recalled.
Then, prosecutor Chris Darden asks a former glove executive to compare the gloves Simpson wore at a Bengals-Bills game in 1991 to the gloves in this case.
Based on what I've seen, I would say that this is Styles 70263, size extra large brown, knowing that I had measured the defendant's hand.
How certain are you of that?
I'm 100% certain.
Mr. Rubin, have you tried to be completely impartial in this case?
Absolutely.
On cross-examination, defense attorney Robert Blazier reads a letter Richard Rubin wrote to the prosecution.
Maybe I can make it to the victory party, exclamation point, exclamation point.
Correct.
Now, is this party being planned before the defense started?
This statement was made in jest. it meant nothing.
Will the jury believe this witness? After so many months, are they listening at all?
All right, Mr. Harmon, you may call next witness.
Gary Sims, a key DNA expert for the state, returns to the witness stand.
My name is Gary
His mission,
Sims,
to rebut a defense witness who said that contamination at the police crime lab made Sims' results unreliable. Sims explains that new results from yet another test confirms blood found on the center console of O.J. Simpson's Ford Bronco came from Simpson and Ronald Goldman.
The finding of that pattern in the console is consistent with a mixture of the banding pattern of the defendant, Mr. Simpson, and also the contribution from Mr. Goldman.
And this is really
But defense attorney Barry Scheck argues that the results cannot be trusted because Simpson's Bronco, poorly secured in police custody, was ripe for tampering.
Let me ask you to assume that between June 14th and August 26th, the Bronco automobile was put into a tow yard, that no records were kept as to who entered or left it between June 14th and August 26th, that unauthorized personnel were in and out of that Bronco automobile, that is, non-police personnel. They were in the seats, they were looking around the car. Would you consider that an appropriate way to preserve the integrity of biological evidence?
Well, I don't think that should be allowed.
The defense says the Bronco and other evidence was smeared with O.J. Simpson's blood in an attempt to frame him for murder. But what if prosecutors can show that no blood was missing to be planted? Marcia Clark plays a videotape of a police nurse who says that when he testified earlier, he overstated the amount of blood he drew from O.J. Simpson.
I came to the conclusion that I was wrong in the statement I made, that I didn't draw ACCs, that I drew about 6 to 6.5.
If true, that means no blood was missing for police to plant on evidence, as the defense maintains.
Do you solemnly swear the testimony you're about to give before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, have a seat, sir.
Douglas Diedrich, a special agent from the FBI, is called to square off, in effect, against Dr. Henry Lee, the nation's preeminent forensic scientist. When Lee testified for the defense, he said blood patterns found on Ronald Goldman's jeans could have been the shoe prints of a second killer. Agent Diedrich disagrees.
And what opinion did you form, sir?
Well, that the pattern that was prepared from the test imprint of the shirt could have produced the imprint patterns or the parallel lines that are present on the jeans.
You are not saying that you can positively identify these patterns as being from Ron Goldman's jeans?
That's right, I can't.
And you're not even saying that it couldn't have come from jeans worn by another person?
I'm not saying that, yes.
And you're not even saying that it could be jeans, that it is necessarily an imprint made from jeans.
That's right. All right, Ms. Clark, people's next witness.
Yes, Your Honor. Thank you. Mr. Bill Boziak.
The state's next witness challenges another one of Dr. Henry Lee's key findings, that bloody parallel lines found on Nicole Brown Simpson's walkway could have been the shoe prints of a second killer.
You've heard Dr. Lee's testimony in large part, correct?
Yes, I have.
Has anything you've seen or heard since your testimony in this case when you previously appeared that causes you to waver at all in your opinion that there was one set of shoe prints on June the 13th, 1994 at Bundy, all of which were size 12 Bruno Magli prints?
Nothing has changed my opinion, no.
And has anything you've seen or heard caused you to change your opinion that the defendant is included as a candidate for wearing those size 12 Bruno Magli shoes?
No.
Thank you, sir. I have nothing further.
A continent away, Dr. Henry Lee defends himself.
I feel a little bit disappointed about the whole process. The bottom line, I know you're going to ask me the question whether or not I'm going to go to LA rebuttal. One-time experience is more than enough. Life have to go on besides O.J. Simpson case.
Back in Los Angeles, Judge Lancito assures weary jurors the end is in sight.
And I know you're paying attention. I know it's tough, but hang in there. We're almost there. All right, anything else from the people?
Prosecutors, fearful of a jury meltdown, have raced through their rebuttal at breakneck speed. From a list of 60 possible witnesses, they called only 12.
The people will conditionally arrest rebuttal subject to the matters the court is aware of.
People having rested their rebuttal
The
case.
condition Marcia Clark mentions is the defense resting its case, which it still has not done.
Los Angeles Police Department Detective Philip Van Adder.
O.J. Simpson's attorneys want to end their case by challenging lead investigator Philip Van Adder. They say they have new proof that O.J. Simpson was a suspect when Detective Van Adder and his fellow officers entered Simpson's property without a search warrant.
Philip Van Adder.
Entering a person's home without a warrant violates their right against unreasonable search and seizure, unless it's an emergency. If the defense can show O.J. Simpson's rights were violated, it could conceivably succeed at getting all of the evidence police seized at Simpson's home thrown out.
Was he coming?
But as defense attorney Robert Shapiro finds out, Detective Van Adder stands by his story emphatically.
Is there any doubt in your mind that you conveyed to the jury under oath that when you went to Rockingham, Mr. Simpson was not a suspect?
There's no doubt in my mind. Mr. Simpson was no more of a suspect at that point than you were, Mr. Shapiro.
At that preliminary...
Prosecutor Brian Kelberg cross-examines the veteran detective.
Bottom line, if you thought Mr. Simpson was a suspect when you first are going from Bundy to Rockingham, number one, would you have told that to this jury?
You bet I would have.
But the next defense witness could hurt Detective Van Adder's story. FBI agent Michael Wax recalls what he heard Van Adder say on a cigarette break outside the district attorney's office.
Something to the effect of not going up to the house to save victims, and that he was a suspect.
All right, well, let me ask you specifically if this is what you indicated in your interview on September 16th, 1995, in the DA's office. Quote, "We didn't go up there with the intention of saving lives. He was the suspect." Isn't that what you said? He said?
I said that I heard something to that effect. I also said in the statement, I do not recall the exact words.
Good afternoon, ladies and gentlemen, and good afternoon, Agent Wax. Agent Wax, the tone you heard in Mr. Van Adder's voice as he was saying the comment you heard him say was one of sarcasm, wasn't it?
Overruled. Counsel, that objection is not well taken. This is cross-examination. Proceed.
In my opinion, it was totally sarcastic, yes.
At this time, I'm going to allow the prosecution to call a witness in rebuttal to some of the defense case that we just heard, again, out of order, but in order to use your time and our time most efficiently.
I do.
Keith Bushy was the commander of the West Los Angeles Police Department the night Nicole Brown Simpson and Ronald Goldman were killed. He says he sent 4 detectives to Simpson's home, not because Simpson was a suspect, but to spare him more grief.
I wanted her relatives to learn of her death through the family and not through the media. And the sooner we could make that notification, the more likely that would occur.
Good morning, Commander Bushy.
Good morning. How are you?
Doing fine. How are you?
Good. Thank you.
Did you know that Mr. Simpson was the ex-husband?
I believe that I did.
And under LAPD policy, and in notifying the next of kin, Mr. Simpson would not be the next of kin, would he?
I don't know that...
Well, have you read your policy lately, sir?
Well, no, I haven't read it lately, but that would certainly be the most logical person to contact for those children there.
Let's get back to my question. And my question, under the LAPD policy regarding next of kin, the ex-husband would not be the next of kin. Wouldn't her family, wouldn't her mother and her father be the next of kin, sir? Isn't that correct?
They would be the next of kin, sure.
Right. Did you take any efforts to have them notified, sir?
I did not know.
Thank you, sir.
All right, Commander, thank you very much, sir. You're excused.
Thank you.
With the last witness off the stand, the case of California versus O.J. Simpson inches toward completion.
How can I say there's no problem?
But the sniping between the lawyers continues.
It's astonishing what we've sunk to here.
Thank you, Your Honor.
The next battle carries far more weight. What the jury will be told about the law.
Yes, these are premeditated murders, that the defendant did not commit.
The defense makes a bold all-or-nothing demand. Decide whether O.J. Simpson is guilty of first-degree murder or set him free.
They have to look at what effect does rage and anger play.
Prosecutor Brian Kelberg wants jurors to have a broader choice, first or second-degree murder.
This jury should not be placed with that Hobson's choice of either convicting this man of first degree, where they don't believe that has been proved beyond a reasonable doubt, but they know he's a murderer, or set this man free because the law says he's either a first-degree murderer or you've got to set him free. They should not be placed in that position.
Under California law, first-degree murder is defined as all murder which is perpetrated by any kind of willful, deliberate, and premeditated killing with malice aforethought. Second-degree murder is more vaguely defined. It is the unlawful killing of a human being with malice aforethought where the evidence is insufficient to establish deliberation and premeditation.
Murder in the first degree and murder in the second degree.
Judge Lance Ito rules the evidence supports first and second-degree murder for the killings of Nicole Brown Simpson and Ronald Goldman.
Good morning, Your Honor. Good morning, ladies and gentlemen. Your Honor, I'm very pleased to say that we have no further testimony to present at this time, and as difficult as it is, the defense does rest at this point. Thank you.
Ms. Clark, on behalf of the people.
Yes, thank you, Your Honor. Good morning, ladies and gentlemen. We ask the court to receive all of the people's exhibits, and the people rest.
All right, ladies and gentlemen of the jury, you have heard all the evidence, and it is now my duty to instruct you on the law that applies to this case. You must accept and follow the law as I stated to you, whether or not you agree with the law. You must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than innocent. You must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the prosecution and the defendant have a right to expect that you will conscientiously consider and weigh the evidence, apply the law, and reach a just verdict regardless of the consequences.
Good morning, ladies and gentlemen. Finally. I feel like it's been forever since I've talked to you. It kind of has.
It's been 8 months since Marcia Clark or any of the attorneys have spoken to the jury directly.
You have been through so much. You have made a tremendous sacrifice. You haven't seen your children enough. You haven't seen your family enough. You haven't seen your loved ones enough. And all of this in the name of justice, in the service of justice. Your dedication and your selflessness are truly beyond the pale.
Clark begins her closing argument by confronting her biggest problem, Mark Fuhrman.
Did he lie when he testified here in this courtroom, saying that he did not use racial epithets in the last 10 years? Yes. Is he a racist? Yes. Is he the worst LAPD has to offer? Yes. Do we wish that this person was never hired by LAPD? Yes. Should LAPD have ever hired him? No. Should such a person be a police officer? No. In fact, do we wish there were no such person on the planet? Yes. But the fact that Mark Fuhrman is a racist and lied about it on the witness stand does not mean that we haven't proven the defendant guilty beyond a reasonable doubt, and it would be a tragedy if, with such overwhelming evidence, ladies and gentlemen, as we have presented to you, you found the defendant not guilty, in spite of all that, because of the racist attitudes of one police officer.
Clark tries one last time to overcome another problem, the gloves.
If I were asked to put on the gloves, the bloody gloves that were used to murder the father of my children, I would not be laughing. I would not be mugging. I would not be playing games. I wouldn't think it was funny at all. Is that the attitude you expect? The laughing and the mugging? Putting on the bloody gloves that were used to murder the mother of your children? The defendant was last seen standing in the
Then Clark delves into the guts of the case, reviewing the mountain of evidence that she says proves O.J. Simpson murdered Nicole Brown Simpson and Ronald Goldman. First, timing.
From 9:36 until 10:54, the defendant's whereabouts were unaccounted for.
The DNA.
It's his blood. Nobody else is on the planet. No one.
Clark says the way Nicole Brown Simpson and Ronald Goldman were savagely murdered points to Simpson too.
You see rage. You see fury. You see overkill. This is not the mark of a professional killer. These are not efficient murders. These are murders that are really slaughters, that are personal. And in that respect, they reveal a great deal about who did them. No stranger, no Colombian drug dealer. A man who was involved with his intended victim. One who wanted to control her and failed. And in failing, found the one way to keep her under control where she could never slip out of it again. And that man is this defendant.
Clark pleads with the jury to weed out what she calls the smoke and mirrors peddled by the defense. But Judge Ito interrupts. He's furious that the television camera focused on O.J. Simpson's hands while he wrote notes.
It's a very flagrant violation and intrusion into the attorney-client privilege, and I'm inclined to terminate the coverage at this time. All right? So, Mr. Bancroft, I'm going to direct you to turn the camera to the seal, and the television coverage is terminated.
But the judge reconsiders, and the camera is turned back on.
I want to hear Mr. Cochran actually stand up in front of you and tell you he believes the blood was planted. I want to hear that. Because that is incredible. That is absolutely incredible. When you think about that, think, what evidence have you been given to show you how that blood was planted, to show you when that blood was planted, to show you who planted that blood? At the conclusion of all of our arguments, when you open up the windows and let the cool air blow out the smoke screen that's been created by the defense with the cool wind of reason, you will see that the defendant has been proven guilty easily beyond a reasonable doubt.
After an all-day argument, an exhausted Marcia Clark fits together all of the pieces of evidence that she says adds up to Simpson's guilt.
We've proven the opportunity to kill. We've given the time window in which he was able to kill because his whereabouts were unaccounted for during the time that we know the murders were occurring. We have the hand injuries that were suffered on the night of his wife's murder, to the left hand, as we know the killer was injured on his left hand. His reaction to Detective Phillips when he made notification, when Detective Phillips said to him, "Nicole has been killed," instead of asking about a car accident, the defendant asks no questions. We have the manner of killings, killings that indicate that it was a rage killing, that it was a fury killing, that it was not a professional hit. The manner of killing that indicates one person committed these murders, one person with the same style of killing. We have the Bruno Mali shoe print, size 12, his size shoe, all of them consistent, going down the Bundy walk. We have the Bundy blood trail, his blood to the left of the bloody shoe prints. We have the blood in the Bronco, his and Ron Goldman's. We have the Rockingham blood trail. We have the Rockingham glove with all of the evidence on it. Ron Goldman fibers from his shirt, Ron Goldman's hair, Nicole's hair, the defendant's blood, Ron Goldman's blood, Nicole's blood. There he is.
Prosecutor Christopher Darden.
Some people think that because the defendant in this case is a celebrity, that perhaps he is somewhat above the law, that there ought to be special rules for him, or that somehow he should be treated differently than any other defendant. But that's not justice. To understand what happened at Bundy, you need to know what happened between them during the 17-year period that they were together.
911 emergency, operator 461. Hello?
The sounds of Nicole Brown Simpson's screams from a 1989 911 call reverberate inside the courtroom, and later, her battered, bruised face appears.
This is a road map. This is a sign. She wanted you to know who killed her when the time came. This relationship between this man and Nicole, you know, it's like a time bomb ticking away. Just a matter of time before something really bad happened. This thing was like a fuse. It was a bomb with a long fuse.
According to Darden, the smoldering fuse was lit again in October of 1993.
911 emergency. Can you get someone over here now to 325 Agrees? He's back. Please. Okay, what does he look like? He's O.J. Simpson. I think you know his record. Could you just send somebody over here? Okay, what is he doing there? He's throwing my van. Somebody over. Wait a minute, what kind of car is he in? He's in a white Bronco, but first of all, he broke the back door down to get in. Wait a minute, what's your name? Nicole Simpson.
I'm just a messenger. I hate to be the one to stand here and tell you about these things, but, you know, this is a murder case. And this is what he did. All these things we talked about, these are the things that he did.
Darden reminds the jury these are the two people O.J. Simpson brutally killed.
He's a murderer. He was also one hell of a great football player. But he's still a murderer.
Judge Ito, my colleagues on the defense, my colleagues in the prosecution.
Now it's Johnny Cochran's turn.
The Brown family to the Simpson family. Good afternoon, ladies and gentlemen.
Boldly, O.J. Simpson's lead attorney takes direct aim at what the defense contends is the glaring weakness in the state's case, the Los Angeles Police Department.
They allowed this investigation to be infected by a dishonest and corrupt detective. Because of their bumbling, they ignored obvious clues. Because of their vanity, they very soon pretended to solve this crime, and we think implicated an innocent man.
Cochran says the prosecution's theory that O.J. Simpson had enough time to commit the murders between 9:36 and 10:55 just doesn't add up.
If you take the witnesses who we presented, who stand unimpeached, and if you are left with dogs starting to bark at 10:35 or 10:40, let's say, and we know from the most qualified individuals, Henry Lee and Michael Batten, this was a struggle that took from 5 to 15 minutes. It's already 10:55. And remember, the thumps were at 10:40 or 10:45. O.J. Simpson could not be guilty. He is then entitled to an acquittal.
Cochran questions the believability of crucial evidence, the so-called blood trail found at Simpson's home.
If he went in that house with bloody shoes, with bloody clothes, with his bloody hands, as they say, where's the blood on the doorknob? Where's the blood on the light switch? Where's the blood on the banister? Where's the blood on the carpet? It's like almost white carpet going up those stairs. Where's all that blood trail they've been banding about in this mountain of evidence? You'll see it's little more than a river or a stream.
Then Cochran stages a bit of courtroom theatrics, mocking Marcia Clark for her contention that O.J. Simpson was wearing a knit cap disguise on the night of the murders.
Now put this knit cap on. And you've been seeing me for a year. If I put this knit cap on, who am I? I'm still Johnny Cochran with a knit cap. And if you look at O.J. Simpson over there, and he has a rather large head, O.J. Simpson in a knit cap from 2 blocks away is still O.J. Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit. Perhaps the single most defining moment in this trial It's the day they thought they would conduct this experiment on these gloves. They were going to try to demonstrate to you that these were the killer's gloves, and these gloves would fit Mr. Simpson. You don't need any photographs to understand this. I suppose that vision is indelibly imprinted in each and every one of your minds of how Mr. Simpson walked over here and stood before you, and you saw 4 simple words. The gloves didn't fit. This is a case of reasonable doubt. Then Mr. Darden said something very interesting today. He said, I'm just the messenger. Now, how many times have you heard that? I'm the messenger. Don't blame me. I'm just doing my job.
Cochran picks up on Christopher Darden's plea to the jury not to blame him for his message that O.J. Simpson is a murderer.
Whose message is he sending? Who is he representing in this message? Van Adder, the man who carries the blood. Fuhrman, the man who finds the glove.
And, as Cochran suggests, the embodiment of years of racial struggle and evil in America.
This man cannot be trusted. He is central to the prosecution. And for them to say he's not important is untrue, and you will not fall for it. Because as guardians of justice here, we can't let it happen. We'll see you tomorrow. Thank you. Big lies.
The next morning, Cochran continues his emotional appeal, one that moves at least one black woman on the jury to tears.
When you're lying at the beginning, you'll be lying at the end. The book of Luke talks about that. Talks about if you're untruthful in small things, you should be disbelieved in big things. There's no question about that. We've known that all along. So this man, with his big lies, and then we have Fuhrman coming right on the heels, and the two of them need to be paired together because they are twins of deception. Fuhrman and Van Adder, twins of deception who bring you a message that you cannot trust.
Cochran reads a letter from Kathleen Bell, who testified that Fuhrman uttered racial slurs when the two met in the 1980s.
What frightened me even more was that he was a police officer. There was another man not too long ago in the world who had those same views, who wanted to burn people, who had racist views and ultimately had power over people in his country. People didn't care. People said he's just crazy, he's just a half-baked painter. And they didn't do anything about it. This man, this scourge, became one of the worst people in the history of this world, Adolf Hitler. Because people didn't care, didn't try to stop him. He had the power over his racism and his anti-religionism. Nobody wanted to stop him, and it ended up in World War II, the conduct of this man. And so, Fuhrman was to take all black people now and burn them or bomb them. That's genocidal racism. Is that ethnic purity? What is that? What is that? We're paying this man's salary to espouse these views? Maybe this is one of the reasons we're all gathered together here this day, 1 year and 2 days after we met. Maybe there's a reason for your purpose. Maybe this is why you were selected. There's something in your background and your character that helps you understand this is wrong. Maybe you're the right people at the right time, at the right place to say no more.
He is one of the most disgusting human beings.
The comparison to Hitler triggers a ferocious reaction from Ronald Goldman's father.
He suggests that racism ought to be the most important thing that any one of us ought to listen to in this court, that any one of us in this nation should be listening to. And it's because of racism we should put aside all other thought, all other reason, and set his murdering client free. He's a sick man.
As the judge has pointed out a number of times, my colleague, Mr. Neufeld, and I, we're from New York City, more specifically, we're from Brooklyn.
Barry Scheck stands before the jury now with the difficult task of arguing against the forensic, physical evidence the heart of the state's case for the defense. He picks up where Johnny Cochran left off, with an attack on the credibility of the police.
The point is, every explanation that they're desperately trying to come up with is a highly improbable inference. The most likely and probable inference is the one that is not for the timid or the faint of heart. Somebody played with this evidence. And if that can happen, that's a reasonable doubt for this case. Period. End of sentence. End of case.
Scheck concludes his portion of the defense summation with a bold warning about the state's evidence.
There is something wrong. There's something terribly wrong about this evidence. Somebody manufactured evidence in this case. There's missing blood. There's EDTA. There's questions, serious, deeply troubling questions. You must distrust it. You have to distrust it. You cannot render a verdict in this case of beyond a reasonable doubt on this kind of evidence. Because if you do, no one's safe. No one. The Constitution means nothing. This cannot, will not, shall not happen in this country with you good people. It just won't. Thank you very much.
I'm back, as I promised you I'd come back, to try and...
Before his final words to the jury, Johnny Cochran defines reasonable doubt, a legal concept that would shape the outcome of California versus O.J. Simpson.
A defendant in a criminal case is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty.
Johnny Cochran's summation has spanned 2 days. He's quoted the Bible, Cicero, and Abraham Lincoln, the American president who freed the slaves. Now he asks the jury to free O.J. Simpson.
By your decision, you control his very life in your hands. Treat it carefully, treat it fairly. Be fair. Don't be part of this continuing cover-up. Do the right thing, remembering that if it doesn't fit, you must acquit. That if these messengers have lied to you, you can't trust their message. That this has been a search for truth. That no matter how bad it looks, if truth is out there on a scaffold and wrong is in here on the throne, remember that the scaffold always sways the future. And beyond the dim unknown standeth the same God for all people, keeping watch above his own. He watches all of us, and he'll watch you in your decision. Thank you for your attention. God bless you.
All right, at this time, the defense has concluded their summation, and the prosecution now has the opportunity to offer their rebuttal.
I heard the words they spoke yesterday about the Constitution.
Though he is likely referring to the Declaration of Independence, Christopher Darden says the words of our founding fathers have vastly different implications for this case than what defense attorneys told them yesterday.
What I saw some stuff in the Constitution about Ron and about Nicole. And the Constitution said that Ron and Nicole had the right to liberty. It said that they had the right to life. It said that they had a right to the pursuit of happiness. It said that Nicole didn't have to stay with him if she didn't want to stay with him. That's what the Constitution said. And I looked further, and I looked in the Constitution to see if it said anything about O.J. Simpson. And you know what it said? It said he doesn't have the right to take those lives.
I believe in this job. I believe in doing it fairly and doing it right. And I like the luxury of being a prosecutor.
Marcia Clark stands before the jury one last time. Her face shows the exhaustion that she and everybody else feels.
Ladies and gentlemen, I can come to you and I can say, don't convict. It's not here. I have that right. I have that luxury. This job gives me that luxury. It doesn't give me a lot of money, but it gives me that luxury. I can get up in the morning and look at myself in the mirror and say, I tell you the truth. I will never ask for a conviction unless I should, unless the law says I must, unless he is proven guilty beyond a reasonable doubt on credible evidence that you can trust, that you can rely on. I can never do it otherwise. That's my obligation. And that's why I'm standing here before you today, because we have proven it to you, ladies and gentlemen. If I thought for 1 minute there was a conspiracy...
Judge Ito sends jurors out of the courtroom and tells Clark not to inject her personal opinions into the case.
We're close here, counsel.
Your
Honor, in view of the...
This has been highly improper. I'm sorry.
Sit down. You're close, Miss Clark.
But the prosecutor defends herself.
When counsel takes off the gloves, makes personal attacks the way he has, saying basically that we're criminals, then we have the right, under the law, to correct that misimpression.
That sparks one last heated argument.
But this is way, way over the line. I mean, I've been teaching law for 18 years, and I've never heard this kind of stuff.
Barry Scheck insists that Clark should not be allowed to vouch personally for the reliability of the evidence. Judge Ito agrees and cautions Clark.
I don't want to hear any more ayes.
Right. Uncontradicted.
After the warning, Clark resumes her argument, unveiling a giant pyramid-shaped chart containing what she says is all of the unrefuted evidence that the state has produced. The defendant's unaccounted-for time on the night of the murders.
Nobody's contradicting that.
The bloody leather gloves.
The left glove at Bundy and the right glove at Rockingham are Eris-like gloves, size extra large. Uncontradicted. Nicole Brown bought 2 pair of Eris-like gloves at Bloomingdale's in New York on December 18th, 1990. Testimony that is uncontradicted.
The blood, hair, and clothing fibers of the killer and his victims at the crime scene, in O.J. Simpson's Bronco, and at his home.
Testimony that's uncontradicted.
Clark ridicules the defense conspiracy theory, pointing out why, from the state's viewpoint, O.J. Simpson had to raise this claim. He's guilty and he's desperate.
Now, the problem with it really is, though, you have to buy the planting theory. You have to buy this far-out idea, this stuff, because otherwise, if you don't, he's guilty. Guilty. He's got Ron Goldman's blood in his car. What's it doing there? That's it. That's it. He's guilty. So they have to find an excuse. And that's why you have this flailing about. You have contamination, you have planting, you have contamination and planting and or planting. You've got everything to explain it all away. Everything. But the theories get wilder and wilder because the proof is so devastating. There's so much of it, and there's so much to explain.
Then Clark returns to the twin images of O.J. Simpson, the icon, and O.J. Simpson, the killer.
I think it's been hard for all of us to be here and to listen to all of the evidence. In this case, evidence that proves Mr. Simpson is guilty, because none of us wanted to believe it. We all wanted to believe that our image of him was right. And we all know that we never knew him exactly, but we kind of felt like we did. And it's really kind of hard to have to believe that the man we saw in the movies and the commercials could do this. But he did. And the fact that he did doesn't mean he wasn't a great football player. It doesn't mean he never did a good thing in his life. Nothing takes that away. That's still here. It'll always be here. But so will the fact that he committed these murders. And even though it's a hard thing, still it cannot mean that you let a guilty person go free.
Nearing the end, Clark brings the case back to the victims.
Usually I feel like I'm the only one left to speak for the victims, but in this case, Ron and Nicole, they're speaking to you. They're speaking to you. And they're telling you who murdered them. Nicole started before she even died. Remember back in 1989, as she cried to Detective Edwards, "He's going to kill me. He's going to kill me." And Ron, he speaks to you in struggling so valiantly He forced his murderer to leave the evidence behind that you might not ordinarily have found. And they both are telling you who did it with their hair, their clothes, their bodies, their blood. They tell you he did it. He did it. Mr. Simpson, Orenthal Simpson. He did it. They told you in the only way they can. Will you hear them? Or will you ignore their plea for justice? Or as Nicole said to Detective Edwards, you never do anything about him. Will you?
Now, the prosecutor's final plea. Nicole Brown Simpson's anguished voice fills the courtroom for the last time, and photographs of both her battered face and Ronald Goldman's bloody corpse flash on a screen.
911 emergency. Can you get someone over here now to 325 Gretna Green? He's back. Please. Okay, what does he look like? He's O.J. Simpson. I think you know his record. Could you just...
Ladies and gentlemen, on behalf of the people of the state of California, because we have proven beyond a reasonable doubt, far beyond a reasonable doubt, that the defendant committed these murders, we ask you to find the defendant guilty of murder in the first degree of Ronald Goldman and Nicole Brown. Thank you very much.
Do not decide any issue in this case by chance, such as the drawing of lots or by any other chance.
Judge Ito, who for nearly 9 months has told jurors not to discuss the case among themselves, tells them to do just that.
It is rarely helpful for a juror at the beginning of deliberations to express an emphatic opinion on the case or to announce a determination to stand for a certain verdict. When one does that at the outset, a sense of pride may be aroused, and one may hesitate to change a position even if it is shown to be wrong. Remember that you are not partisans or advocates in this matter. You are the impartial judges of the facts.
The judge then sends the jurors into the jury room with instructions to buzz 3 times when they've elected a foreperson. Minutes later,
Matter for maybe they have a verdict already and we can go home. Maybe that's it.
with surprising speed, the jury picks a foreperson. But now the 10 women and 2 men of the jury have a far greater duty. They must weigh the evidence and reach a verdict. After another sequestered weekend, the jury starts deliberating.
We have a request for readback from the jury.
They ask to hear the testimony from Alan Park, the limousine driver who drove O.J. Simpson to the airport on the night of the murders.
And when you looked at the curb and you saw the address on that night as you drove over Brockingham, you indicated before that you did not see the white Bronco there? Answer no.
It could be a good sign for prosecutors. Park testified that Simpson apparently was not at home between 10:22 and 10:55, when prosecutors allege he was committing murder. Minutes later, something utterly unexpected.
Ladies and gentlemen, while we were taking our brief recess, Mrs. Robertson advised me that you buzzed 3 times and indicated that after receiving the verdict forms that you have reached a verdict in this case. Is that correct, Madam Foreman?
The swift verdict stuns O.J. Simpson, but he will have to wait 19 hours to hear the outcome.
I will accept the verdict from you tomorrow morning at 10 o'clock.
Reporters are dumbfounded.
No one knows what this means.
The world is left to wait and speculate.
Quick verdict, what does it mean?
Well, normally in this kind of case, I'd be very afraid that a quick verdict, in fact, means an acquittal, because it's hard to imagine a jury deliberating after 2 hours to send someone to prison for the rest of their life. However, the fact that they read back, which was one of the strongest prosecution witnesses, and given the amount of evidence that the prosecution believed they had, certainly an argument could be made that they had heard the evidence, listened to the evidence, it was overwhelming, and there was nothing to talk about.
100, if not thousands, have gathered.
The next morning, throngs of curious trial watchers wait outside the courthouse. Dozens of police officers stand on tactical alert.
All right, back on the record in the Simpson matter.
Inside Judge Ito's courtroom, the defendant and the lawyers sweat it out. The jury enters. 150 million people are watching and waiting.
All right, Mr. Simpson, would you please stand and face the jury? Mrs. Robertson.
Superior Court of California, County of Los Angeles, in the matter of the people of the state of California versus Orenthal James Simpson, case number BA097211. We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder in violation of Penal Code Section 187A, a felony upon Nicole Brown Simpson, a human being, as charged in count 1 of the information. Superior Court of the State of California, County of Los Angeles, in the matter of the people of the State of California versus Orenthal James Simpson. We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder in violation of Penal Code Section 187A, a felony upon Ronald Lyle Goldman, a human being, as charged in count 2 of the information. We, the jury, in the above entitled action, further find the special circumstance that the defendant, Orenthal James Simpson, has in this case been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree to be not true.
Let's have it quiet in the courtroom, please.
The jury has set O.J. Simpson free.
Robertson, would you please poll the jurors?
It's a precautionary measure by Judge Ito to confirm that the jury is sure.
Juror number 1, as to count 1, is this your verdict? Juror number 2, as to count 1, is this your verdict? Juror number 3, as to count 1, is this your verdict? Juror number 8, as to count 1, is this your verdict? Juror number 9, as to count 1, is this your verdict? Juror number 10, as to count 1, is this your verdict? Juror number 11, as to count 1, is this your verdict? Juror number 12, as to count 2, is this your verdict?
From the victims' families, tears of disbelief.
Thank you.
From O.J. Simpson's family, tears of joy for their answered prayers. Outside the courthouse, high spirits and shock. Across America, response to the verdict is divided, largely along racial lines.
I feel that this is total injustice, and I think O.J. Simpson's going to have to answer to God because he's guilty.
The defendant having been acquitted of both charges, he is ordered transported to an appropriate sheriff's facility and released forthwith.
After 474 days in jail, O.J. Simpson is free.
He's free on the freeways.
He immediately returns to the Los Angeles freeways in a white van, lending a certain symmetry to the saga that began nearly 16 months before. O.J. Simpson is going home.
I wondered what...
Judge Ito's courtroom teems with reporters. O.J. Simpson's eldest son, Jason, reads a statement from his father.
I'm relieved that this part of the incredible nightmare that occurred on June 12, 1994 is over. My first obligation is to my young children, who will be raised the way that Nicole and I had always planned. My second obligation is to my family and to those friends who never wavered in their support. But when things have settled a bit, I will pursue, as my primary goal in life, the killer or killers who slaughtered Nicole and Mr. Goldman. They are out there somewhere. Whatever it takes to identify them and bring them in, I'll provide somehow. I can only hope that someday, despite every prejudicial thing that has been said about me publicly, both in and out of the courtroom, people will come to understand and believe that I would not, could not, and did not kill anyone.
O.J. Simpson's mother, Eunice.
I knew that my son was innocent.
Simpson's sister, Shirley Baker.
And I tell you, I just feel like standing on top of this table and dancing a jig, and I just thank you guys.
I'd like to know what role race played in this trial.
I think that from a standpoint of race, it was introduced by this witness, Fuhrman. This stuff about playing a race card is preposterous. It would malpractice if a man has racist views in a case and a lawyer doesn't pursue that. Anybody who says that doesn't know how to try cases, doesn't know anything about anything. So you have to pursue it because that's your job.
But Robert Shapiro says he was always uncomfortable with the way Johnny Cochran dealt the race card.
There has been a difference of opinion with many of the lawyers. I said from the beginning that race was not an issue in this case and should not be an issue. I still feel the same way.
Shapiro would skip the defense team's victory party that night. Instead, he tells a reporter, quote, "Not only did we play the race card, we dealt it from the bottom of the deck."
We are, all of us, profoundly disappointed with the verdict.
Prosecutors try to put a good face on their staggering defeat.
Everyone here has put in 110%, given their all for everyone, for justice, for the families of the victims, in the effort to see that the lives of Ron and Nicole were not thrown away.
We came here in search of justice. You will have to be the judges, I expect, as to whether or not any of us found it today. But I'm not bitter, and I'm not angry. But I'd also like to thank the lawyers on our prosecution team. I am honored to have
last June 13th, 94, was the worst nightmare of my life. This is the second.
On the property of O.J. Simpson, a very joyous occasion for everyone arriving here at the home.
At 360 North Rockingham Avenue, O.J. Simpson revels in his victory.
Hey, Brenda.
Reporters stake out their first juror.
I think we did the right thing. You know, matter of fact, I know we did.
The next day, Brenda Moran defends the verdict.
We did this on the advice the court gave us. Weigh the evidence. We were fair. It wasn't a matter of sympathy. Wasn't a matter of favoritism. It was a matter of evidence.
Ann Aschenbach says that initially she voted guilty.
I still think very possibly he's guilty. The reason I voted that way, even though at the time I felt I'd probably have to vote not guilty based on my faith in the evidence, I was hoping maybe another juror or jurors would be able to convince me that the evidence was more credible than I really thought it was. That didn't happen. No one really thought it was credible.
Why didn't these jurors believe the so-called mountain of evidence against O.J. Simpson? One big reason is Mark Fuhrman.
He had made a statement that a white woman and a black man together, and there was no problem, he would find a problem. So that made me, in my mind, think he's not credible. I couldn't believe anything he would say.
Well, seeing the type of character he was, I thought it was so possible that he would plant the glove, and that same evidence have gotten into the Bronco. He was there too. That whole portion of it, you know, I couldn't depend on it, so I had to discard it.
Did the gloves fit O.J. Simpson or not?
In plain English, the glove didn't fit.
Was any of the state's evidence believable to any juror?
I think the wife-beating charges, you know, I believe that he had motive to do the crime. I believe he had time to do it, even though other jurors, you know, disagreed with that.
To me, that was a waste of time. This was a murder trial, not domestic abuse.
If I could have believed the blood and trace evidence, I could have voted guilty easily without wavering on it.
Days after his release, O.J. Simpson schedules a live, no-holds-barred interview with NBC. It is the talk of the town. Guilty! But abruptly, Simpson pulls out. His attorney expresses concern.
The lawyers for the plaintiffs in these civil cases are trying to set his deposition.
O.J. Simpson walked out of court a free man, but his legal troubles are far from over. He faces civil lawsuits filed by the family of Ronald Goldman and the estate of Nicole Brown Simpson. In civil court, Simpson will face a lower standard of proof and may be forced to testify. If he loses, jury awards could reach millions of dollars and bankrupt him. As for the attorneys, Robert Shapiro has vowed never to speak to F. Lee Bailey and never to work with Johnny Cochran again. Christopher Darden and Marcia Clark are both writing books. As for the witnesses, Kato Kaelin is an afternoon radio personality in Los Angeles. For Core TV, I'm Greg Jarrett.